All right, good morning. This is it's 8:15 on April 9th. This is the Yelm Municipal Court. My name is Chris Coker. I'm the judge for today. I'm going to start with the 8 o'clock calendar or 8:15 calendar. First matter is going to be City versus Royce Badeau. Mr. Badeau, why don't you come forward? This is cause number 58006875. Mr. Badeau, am I pronounced that correctly? Badeau?
Badeau, correct.
Mr. Badeau is present. So, Mr. Badeau, you're here on a compliance diversion review. You were charged with DUI back on or about February 3rd of 2025. As part of the process, you were back in March of 2025, you entered into a stipulated order of continuance. Looks like you've paid all the costs. Looks like the allegation here is a discharge from treatment. I have a report from Providence Behavioral Health and Recovery. Okay, so it looks like there's some stuff going on with your family or whatever, so you had to pull out of treatment for a while?
Your Honor, yes. Last February 14th, 16th, February, March, and just now April, I have been out of treatment. My health insurance, I'm on Apple Community. It stopped and I can't pay it out of pocket because I don't have a job right now.
Okay.
But I do plan on continuing treatment program. I just need to get back onto the
Right.
state insurance and then they could pay for it. And
Okay. Has the city seen the treatment review? I mean, it shows everything else is fine. He's done everything. He's just had some treatment issues. Okay.
If, you're wanting Mr. Howard, your attorney, to be present during this, is that right?
Yeah, that was just now requested for like legal representation and whatnot, but I figured that we could just, I could tell you guys that I'm gonna continue to do the treatment program as soon as I can get the cost to do it.
What I'm inclined to do on this is, how much time do you think you need? What's a reasonable amount of time? I mean, do you even know?
I just need to check my emails, re-sign up for it. I've been just running around with my head cut off like a chicken, just trying to get stuff done around the house. And
why don't we do this? Why don't we, I will tell, just so the city's aware, I am showing, at least there was PC for a DUI from May of 2025. I don't know anything about that. I don't know if it's my bet is it's a blood draw case.
yeah,
I don't want you saying, don't say anything else.
Do that too, just
Yeah. So my recommendation, I guess my thoughts is kicking this out 90 days. Throwing it on with Haverco. Mr. Badeau, that'll give you a chance to get back in compliance if that's what you decide to do. Also, I imagine the city is going to probably do some more digging into that, whatever there is in Pierce County. Because obviously if that's an issue, then there's going to be different compliance related issues. So why don't we kick it out in 90 days, put it on Dan's calendar, and it'll be on for review. So it'll be at a different time. But we'll go Mr. Haverco is still appointed. We're not gonna take any action without his presence.
gotcha.
Okay, but 90 days, you'll be given contact information how to talk to him. He's gonna likely suggest that you get back in treatment and we figure out what's going on with Pierce this week. Okay.
Thank you, Your Honor.
All right. And then I will sign. Do I need to do an order for that? Okay. Okay. All right, Mr. Badeau, your next court date is going to be July 2nd at 10 a.m. It'll be here, but at 10 a.m. Okay. This is going to have the information on how to contact Mr. Haverco. So you'll be given his information again. My suggestion is you get figure out kind of what's going on with the treatment side of things, and then you give them a call and reintroduce yourself and we'll go from there, all right? All prior conditions remain in effect. All conditions of the SOC remain in effect at this point. It's telling me to check a box. So, okay. Yeah. So he's got to be on, I guess, the inactive probation. Yeah, okay. Did you? Okay, great. Got it. Okay. God dang it. Wait a second. Oh, I see it. Nope, I did it. I can do it. No, it took it, but you have to check the first box and then the inactive box. There you go. All right. All right, Mr. Bordeaux, at the window will be a copy of this order and we'll see you back here on July 2nd. Get a hold of Mr. Haverco. All right, good luck to you. Next matter is City of Yelm versus Christian Cabrera. Mr. Cabrera, come on forward. This is cause number 480299801. Mr. Cabrera is present, charges reckless driving. This is a stipulated order of continuance that was scheduled to end on October of 2025. And it looks like you still owe $250.
Yeah.
Has that been paid?
No, it has not.
Okay, can it be paid today?
I cannot. So I just came in to ask if I can get like another week or two to pay that, and I can pay that.
I'll give you, is 2 weeks a reasonable amount of time?
Yeah, that's perfect.
Let's kick it to the next calendar with the assumption he's gonna pay it. If you pay that
Mhm.
before the next court hearing, you don't have to come.
Yep.
And your appearance will be waived, and I think the SOC would probably be closed, because I think it'd be closed. So all this is kind of, by delaying this, all it's doing is keeping this cloud over your head. So kick it 2 weeks to, it'll be
I
April
can come
20.
here and pay it, right? I can just go to this window.
Go to the window. Yep. You just got to go into the window, have your cause number with you, and they will take care of it at the window.
Alrighty.
Okay, so wait, are we gonna give him an order? Okay. Okay. All right, April 23rd, 8:15. Pay the $250 in full and the hearing will be canceled and you'll get the benefit of the bargain. I want to check one more thing. You also, you've got a failure to stop at a stop sign infraction from September of 2024 that's in collections. You know that?
And it's in collection.
Yeah, it looks, well, at least it looks like it's an FTA status. Maybe the court hasn't sent it to collections yet, but it's $202. So you actually owe $452 to the court. Okay, so my suggestion is get all those things paid. All right.
Yeah.
Okay. All right. We'll see you back here. Well, hopefully I won't see you back here on the 23rd.
Hopefully
Okay.
you will.
Okay. All right. That's, yep. Go to the window. Yep. Good luck. Have a good rest of your day. You too. Next matter, City of Yelm versus Alexander. Is there anybody on Zoom? Yep. Okay. Next, City of Yelm versus Alexander Davis. Neg driving first degree, proof of ADIS is needed. I don't see anything in the court file. Mr. Davis has a pending new charge out of Ferndale Muni. So what's the city's thoughts on Mr. Davis?
City's moving to have a warrant issued, 2,500 cash or bond.
I'll go 1,000 cash or bond based on the charge. Next matter, City versus Lyle Drexler, cause number 5A07508838.
He's in compliance. We received it.
Oh, very good. Okay, very good. And then next matter is City versus William Stubbs, cause number 5A0058322. It's a DUI. We're missing treatment for December, January, February, March. I've got a letter from Nisqually Behavioral Health dated. Oh, this is from us. We sent this on March tenth. Donnie sent it on March tenth to Nisqually Behavioral Health. We have no response as of March 23rd. No response, no response. Is it normal for them not to respond? Like not even like tell us he's not in treatment or anything?
Yeah. no. I'm not a provider, it is a little more hit and miss. Tribal, treatments.
Okay.
than other ones, but usually once they send them a fax requesting it, because that's the way in contact with them, they usually get it.
Yeah, okay. It's a charge of DUI from February 2025 post dispo. He hasn't made any fine payments either. What's the city's thoughts?
5,000.
Let's go 5,000 cash or bond on Mr. Stubbs. All right. Great. Brings us to the 8:30s. Yes.
So, when I say, does that mean that, I'm not having more cookies? Okay. Okay, so I started. Okay, thanks. Okay. So why don't you just come, well, let's wait there for a second, let me. Okay. Okay.
Mr. Haverco, can you hear us?
I can, Your Honor.
Right, you have somebody ready to go?
I did, yeah, let me grab them.
Okay.
Hold on, see. This is, Your Honor, this is Wyatt Ingram. I haven't actually been appointed yet. He is indigent. I believe he does qualify for court-appointed counsel.
All right, this is, we're back on the record, right? City of Yelm versus Wyatt Ingram, cause number 5A015069. Mr. Ingram is present in custody. Mr. Haverco, I'll go ahead and appoint you for this case based on your statements regarding his economic status.
Thank you, Your Honor. And pursuant to that, I've had an opportunity to discuss the matter with Mr. Ingram, and he comes on before the court this morning for an arraignment, which is to be read the charges in open court and so on. With that in mind, he would like to waive that process and proceed directly to a plea. I have prepared a statement of defendant on plea of guilty, which I've reviewed with him, and I believe he's ready to proceed.
All right, and you are Wyatt Ingram?
Yes, sir, I am.
All right, Mr. Ingram, I'm going to open up what we've got here really quickly. I have a statement of defendant on plea of guilty. What was your last level of education, Mr. Ingram?
12th and higher.
All right, and you feel like you've had enough time to go over this plea of guilty with Mr. Haverco?
Yes, sir.
Did he read it to you, or did you read it to yourself, or both?
Both.
Okay. So I'm going to go over some points on this. First off, you're charged with theft in the third degree. This is what's called a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand in this plea of guilty, there's a number of constitutional rights at paragraph 5 that you're giving up by pleading guilty.
Yes, sir.
All right. And you understand there's a recommendation here that I don't have to follow. I could sentence you up to the maximum no matter what the parties recommend.
Yes, sir.
And you've discussed any potential immigration consequences with Mr. Ingram?
Yes, I have, Your Honor.
Thank you. All right, Mr. Ingram, paragraph 11 contains a statement, and that statement says, on February 23rd, 2025, in the city of Yelm, I stole merchandise from Walmart by leaving the store with unpaid for merchandise with the intent to retain the merchandise without paying for it. Is that your statement?
Yes.
So as to the charge of theft third degree, alleged to have occurred on February 23rd, 2025, how do you plead, guilty or not guilty?
Guilty.
Yeah, I'll find your plea is made knowingly and voluntarily, as no one's made any threats or promises of any kind to cause you to enter the plea. Mr. Haverco, we go into sentencing today?
We are, Your Honor.
I'll hear from the city first. All right. Mr. Haverko.
It's an agreed recommendation, Your Honor. He's been, this is the fellow who, he didn't feel well enough to come to court, last court date. So we basically set it over, so he's been in custody, in addition to any prior days prior to the last court date. He's been in custody for at least the last 2 weeks.
Okay. All right, Mr. Ingram, anything you'd like to say before sentencing? You don't have to say anything, but this is your opportunity.
No, Your Honor.
Okay. Were you not feeling well a couple weeks ago because you were coming off drugs, or what was it?
Yes, I was detoxing off of drugs, but I do actually have a plan to go to treatment after I get out.
Okay. And I'm looking at your record, you know, the one we're dealing with today is from 2025. And since then you had three, or two additional thefts. One you just resolved in January. Mr. Haverko, what do you think he's got? 14, 15 days credit?
Well, let's see, you remember, because you
He
didn't.
has
come to
15
court
days
last-
credit.
How long have you been in court prior to last?
He has 15 days credit.
He believes he's been in custody since the 25th.
Yeah, so 15 days. All right. All right, Mr. Ingram, what I'm going to do is this. I'm going to follow the recommendation, which is I'm going to post 364 days in jail. I'm going to suspend 349. I'm going to give you credit for those 15 days that you served. Just so you know, if you hadn't already served 15 days, you probably would have been looking at about 15 days anyways. So you served them. It got you able to get your head straight, hopefully.
Yes, sir.
I hope you use this to transition into some sort of meaningful treatment that will keep you from having to come back.
Yes, sir, I will.
All right. Going to impose $5,000 fine, going to suspend all $5,000 for a period of 12 months. Conditions are going to be no law violations. Was this a Walmart case, Mr. Haverko?
Yes.
Okay. Not to go to Walmart. You've already been trespassed from Walmart, but that'll also be a condition of your release. I'm not going to impose any fines. Basically law-abiding behavior and don't go onto the property of Walmart. You understand those conditions?
Yes, Your Honor, I do.
All right, Mr. Ingram, I wish you good luck.
Thank you, Your Honor.
Thank
You have
you.
an amazing day.
Thank you, Your Honor.
Too. And Mr. Haverko, I've signed that order, so.
David? Your Honor, this is J. Trinan Roberts. The matter comes on for a pretrial hearing. And we do have a proposed agreement, that being he's going to enter a plea on count 2 to the reduced charge of unlawful use of drug paraphernalia. And then upon the court's acceptance of that plea, the city would move to dismiss the dangerous knives.
All right, and are you Datrian Roberts?
Yes, sir.
All right, good morning, Mr. Roberts. This is cause number 6A0006653. Mr. Roberts is present in custody with counsel. I have before me a statement of defense on plea of guilty to an amended charge of unlawful use of drug paraphernalia. And assuming that plea is accepted, there's also a recommendation to dismiss another count that's part of that case number. Mr. Roberts, have you had enough time to go over this plea form with Mr. Haverko?
Yes, sir.
Did he read it to you? Did you read it yourself, or both?
Both.
Okay. And what's your highest level of education, Mr. Roberts?
I got my high school diploma.
I'm sorry?
I have my high school diploma.
Okay. Oops. Okay. All right. Unlawful possession of drug paraphernalia is a misdemeanor, which means the maximum penalty is 90 days in jail with a $1,000 fine. You understand paragraph 5 in this document has a number of constitutional rights that you're giving up by pleading guilty?
Sir.
Okay. And you understand there's a recommendation I don't have to follow. I could sentence you up to the maximum.
Yes, sir.
Okay. So paragraph 11 states, on January 23rd, 2026, in the city of Yelm, I knowingly and unlawfully possessed a baggie in which I had stored a controlled substance for future use. Is that your statement?
Yes, sir.
So as to the charge of unlawful possession of drug paraphernalia, how do you plead, guilty or not guilty?
Guilty.
Okay, find your plea is made knowingly and voluntarily, no one's made any threats or promises of any kind to cause you to enter the plea. And Mr. Averco, just briefly, did you discuss any potential immigration consequences?
I did, Your Honor.
All right. And based on the plea, acceptance of the plea of the unlawful use of drug paraphernalia, is the city moving to dismiss the count related to dangerous knives?
Yes.
All right. So I'll go ahead and grant that motion. Turning to sentencing, I'll hear from the city first. Okay, Mr. Averco?
It's a great recommendation, Your Honor.
Okay, Mr. Roberts, anything you'd like to say before sentencing? Again, you don't have to say anything if you choose not to.
Yes, sir.
Okay, so gonna impose, so I'll follow the recommendation, gonna impose 90 days in jail, gonna suspend 87 for a period of, so forgive you credit for 3 days. Gonna impose a $1,000 fine, suspend $1,000 for a period of 12 months on the following conditions. You appear timely at all scheduled court hearings, have no criminal law violations. Do you understand those conditions, Mr. Roberts?
Yes, sir.
Also, we're forfeiting the knives in this case. Is that agreed to by the parties?
Correct.
Okay. All right, Mr. Roberts, I've signed this order. If you have any questions about it, you can ask Mr. Haverco, but I wish you good luck, okay?
Thank you, Your Honor. Cody? This is for arraignment. Yeah, we're just gonna argue your conditions of release and our locally. This is, Your Honor, this is Cody, how do you pronounce your name? Galaviz. Matter comes on for arraignment, which we're gonna do today.
All right, this is City of Yelm versus Cody Galaviz, cause number 680205611. Mr. Galaviz is present in custody with counsel. Mr. Haverco, I'll turn it over to you.
I do believe he, by the way, qualifies for court appointed counsel. He doesn't have any income at this time.
All right. I will point you so we can we'll start the arraignment.
Okay, and pursuant to that, would stipulate to probable cause, ask the court to enter not guilty plea, would like to address release conditions.
All right. So Mr. Galaviz, I'm going, based on statements of counsel, I'm going to enter a plea of not guilty on your behalf to the one count of theft in the 3rd degree. Now I'm going to turn to the city for conditions of release.
Your Honor, city's fine with PR.
Okay, is there any out-of-state history on this? Have you looked? I don't show any. I showed this is the only. It's Cody, C-O-D-Y.
Yeah, it was out of Thurston County.
Didn't show up on your history.
Issued back from 2021.
How many?
2021.
Yeah, but how many?
Just one.
What, for what?
For a 2nd degree felony of aggravated assault, 2nd degree aggravated assault.
Thurston County Spirit Clerk? Was it as an adult or juvenile?
Adult. It was in 2021.
He thinks he has as I recall, there was really nothing on his DCH, but he says he's got a 2021 felony assault 2 from Thurston Superior Court, but
Okay. Well, I'm not showing any, this is the only similar offense that I see.
right, that's what I saw too, Judge.
All right. So Mr. Galvez, I'm going to follow the recommendation in terms of release conditions. We're going to PR release you. I'm going to appoint Mr. Haverco. You're going to be released on the following conditions. You appear timely at all scheduled court hearings. You're going to have no criminal law violations. Keep your address and everything up to speed with DOL, and you're not to go onto the Walmart or property of Walmart. Do you understand those conditions?
Did you say that last part again?
Yeah, you're not to go on any of the property of Walmart. That includes the parking lot or the store itself. Do you understand that?
Yeah. I understand.
All right. Let's give him an out of custody Haverco court date, please.
I have do you know the zip code out in Ocean Shores?
It's 98569.
98569. I have an address I can give to the
Okay.
clerk.
And the next court date, Mr. Galaviz, is going to be May 21st of this year at 10 a.m. You're going to be given a copy of this order. it's gonna have information on how to contact Mr. Haverco. Make sure Mr. Haverco has a good number for you. And then when you get this, I want you to check in with Mr. Haverco well before May 21st, okay? Is
Okay,
Thank you, Your Honor.
that's you.
that all for Mr. Galaviz?
Yes.
All right.
Thanks for your time today.
Your Honor, this is Ashley Gimbert. Matter comes on for arraignment. I have spoken with her. I do believe that this person is indigent and would qualify for court-appointed counsel.
Okay. This is City of Yelm versus Ashley Gimbert, cause number 580-448-995. Ms. Gimbert is present out of, or in custody with Mr. Haverco. Mr. Haverco, based on statements, I will appoint you for, at this time for the arraignment.
Thank you, Your Honor. Pursuant to that, would stipulate to probable cause, ask the court to enter a not guilty plea, and then would like to address release.
All right, Ms. Gimbert, based on statements of counsel, I'm going to find probable cause purposes hearing only enter a plea of not guilty on your behalf. Turn to the city in terms of conditions of release. I'm looking at warrants out of Centralia, Olympia, Centralia. Going back almost all within current, they're all within this last year, give or take.
See those as well.
And I see a pending theft, pending theft in Thurston County. One pending theft in Thurston County, pending obstructing, pending theft that she's on a warrant for out of Olympia. So what's this?
City would like to see this. Awesome.
Okay. Bail request from the city is $1,000, Mr. Haverco. Your thoughts?
Well, yeah, I saw those. There were a few warrants. And don't you have a court tomorrow
Yeah,
with Thurston District Court?
we're waiting on Thurston District Court, because court and C
Okay.
tomorrow.
So
I've been in here for a week already.
okay, been in jail for a week, and apparently has court tomorrow on the district court matter. So that warrant, I'm presuming, is going to go away. Was provided with an address in the Olympia area and a phone number. She promises to appear for any and all future court appearances. I know that, I understand that's kind of taken with a little bit of grain of salt in light of the warrants, but that's, her position. And so she'd still like an opportunity to try to take care of these matters out of custody. So I'd ask for her PR.
Okay. All right, Ms. Gimbert, I'm going to impose $2,500 cash or bond on this matter based on the fact that I issued a warrant back in early April. Based on your non-appearance, you have several active warrants out of various jurisdictions. I think Tumwater's got a hold on you, I think, as well. So even if we were to release you, I don't think you're going to be released. So at this point, we're going to hold you on a $2,500 cash or bond. I'll work under an assumption Ms. Gimbert's not going to be able to post. So we'll set this at the next due course, which I think would be April 23rd.
Correct. 8:30.
Wait, so tomorrow when I have court, when they release me for court tomorrow, I have to stay in jail?
On our, unless you have the ability to appear for court from jail, the answer is yes. So next court date is going to be April 23rd for us. At what time? At 8:30 a.m. If you are to post, the conditions are going to be as follows. You're to make all timely court hearings, keep your address up to speed with the court, not to commit any criminal law or criminal traffic violations, and you're to have no contact with Walmart. Otherwise, we'll see you back here on April 23rd at 8:15 or 8:30 a.m.
Thank you, Your Honor.
Thank you. It's not letting me sign.
Your Honor, this was the very last minute add-on. This is Amador Contreras. It's essentially a show cause probation violation hearing. I believe he entered a SOC, a slow neg, in or around, I think, August of 2024, I believe. And still kind of having some issues with trying to comply. He obviously would still like more time to somehow try to comply. I don't know whether, based on how much time is left on the SOC, whether or not there's enough time remaining.
Okay, hold on one second.
Oh,
I mean, the box was indicating I could sign it, but it wouldn't.
But it went-
Wasn't.
yeah.
So
can hear you now.
I'm thinking now it's short. It's a.
it worked. Thank you. Okay, all right, sorry about that. And you are Amador Contreras, cause number 480398069. This is on for a compliance diversion. And Mr. Contreras, remember this matter. So you're on a contract with the city that enables you to get a benefit of a bargain that you're apparently not, at least according to the city, not in compliance with. So the issue we run into here is this is a contract between you and the city. The court's really not even a party to that, to the extent that it's up to the city whether or not they think you've violated the conditions to a sufficient degree to warrant revocation. So what I'm going to do, I'll turn it over to the city. What are the city's thoughts on this? I've got a discharge summary dated, we received it in June of last year. Discharge reason was lack of attendance. There was also some continued use issues. It was a 2-year SOC entered on September 12th of 2024. There's been limited costs paid, et cetera.
City like accepts revocation.
Okay. So Mr. Averco, the city's indicating they'd like to set this matter for revocation. Thoughts?
There's just a probation violation hearing to talk about the case a little more in depth. Yeah, let's go ahead and just set it on, either a 10, if the court's willing to release him on a 10 or 11 o'clock calendar for non-compliance.
What are the city's thoughts on conditions of release at this point? When was he picked up? Mr. Haverko, if you know.
He was arrested yesterday.
Okay. Again, this is an old, what's the city's thoughts?
The city's fine with the PR.
All right, so, Mr. Contreras, the city is going to, not have any objection to a PR release, which means you'll be released today. I'll be honest with you, I'm a little surprised. So I just want to make it really clear. You're going to be given a new court date. And I also am showing no new law violations since July of 2024. So that's obviously pretty significant, but, I am going to release you on your own recognizance. I don't want to mess around with these warrants and you not showing up for court and things like that. Do you understand that?
Yes, Your Honor.
Okay, so, we're going to give you another court date. We're going to reappoint Mr. Haverko or appoint Mr. Haverko, whatever the term will be. And I want you to be in touch with him. And, we're going to set this on for a revocation or a revocation hearing or whatever we want to call it. We'll put it out, I don't want to put it out any further than 30 days. So. No, I'm good with May 21st. I think that'll give Mr. Haverko enough time to get up to speed with Mr. Contreras. Hopefully Mr. Contreras, if he's got anything he can bring to the table, that will give him enough time to deal with that as well. So, Mr. Contreras, we're going to reset this matter for May 21st at what time? At 11 a.m. All right. And you're going to be given information on how to contact Mr. Haverko, and he's going to be given information on how to contact you. And so be in touch with him before May 21st. All right.
Thank you, Your Honor.
Thank you, Art.
Thank you. That should be it for the in custodies, I believe.
So if you're released.
That's a yes. Okay. So do I need are we gonna do just I've got an order on review revocation. Okay, there we go, May 21st. Okay. All right. Didn't let me sign it. What? We gotta mark the defendant placed on inactive. Are you doing that or am I doing that? Right. And do we have any quick ones on the 9 o'clock? Any resets or anything? All right. City of Yelm versus Cole Holmes. Good morning, Mr. Pilon.
Mr. Holmes here with me,
Okay,
on my right.
all right.
I had an opportunity to speak with the city a little over a week ago. We received an offer that Mr. Holmes is accepting. We just need an opportunity for he and I to meet in my office and go over the paperwork before presentation. I'm asking to set this over, I guess we're every 2 weeks. So at the next hearing, and I'm expecting a disposition in the hearing.
Okay. And yeah, I'm frozen too. So we're waiting for the paper, we're waiting for the system. Any objection from the city on kicking this 2 weeks? I will tell you, I'm gonna be out at the next court hearing or so April 23rd, I won't be here. Which means we may have a pro tem, which could possibly be you, or
We make this super.
it would make it super easy.
We could set this on, we could set this on for the set it a little bit more, set this out for the, what the.
First date in May would be May 7th.
I think we should have speedy.
Okay. Any able to fix it? Oh, there we go. Oh, nope, it's not letting me sign.
I did.
You. We'll probably set up a speedy for some important purposes.
I had to do it a few times on my end, so you can see. It should let you know.
Thank you. Okay, all right, now we're back to the Cole Holmes matter. So do we want to go May 7th?
That would be my preference.
Okay. Okay, so Mr. Holmes, we're going to reset this matter to May 7th at probably 9 a.m. And do I need to do a? Okay, so you're just gonna get a notice hearing, so I'm not gonna sign that. You'll just get another notice, have you pick it up at the window, and we'll go from there. Anything else on this matter? All right. All right, and then Mr. Havard or Mr. Pilon is here for one conflict matter. Are you just, what, does he need to just sign something, or? I see a motion to continue in the file.
Well, yeah, he will. And then yes, Miss Polly.
All right, Mr. Pilon, do you want to come take the bench? Okay.
Good morning, Shannon Polly here on Shannon Muscott.
I'm sorry, could you repeat that? Good morning. Hi.
Good morning, Shannon Polly. I'm appearing on behalf of Shannon Muscoff. This would be a 3.4 appearance for Shannon Muscoff.
All right. Hi, Miss Polly. Good morning
Good
to
morning.
you. So it looks like you've proposed a continuance along with a speedy trial waiver. Is that correct?
That's correct. And I am speaking with the prosecutor. Think we planning to have a call later today, so hopefully we'll make some movement in this case before the next hearing.
Okay. Does the city have any objection to this continuance? Okay. All right. Thank you. So for the record, it looks like we have a speedy trial waiver with a commencement date of today, May 7th. And your client is out of custody?
She is out of custody.
Okay, so an expiration date of August 5th. Did you review your client's speedy trial rights with her?
I did. She's aware of this request and of the waiver for speed trial, and she authorized me to waive that on her behalf.
Okay, I am going to need to log in and log off because I am not Mr. Coker and I don't want to sign with his signature. Thank you very much, counsel. I'll sign that continuance and we'll continue this to the next court date, which is going to be,
Yes, May 7th at 9.
sorry, May 7th at 9 a.m. So,
Perfect. Thank you very much.
all right, thank you, counsel. Thank you. All right, so.
Yeah. Gonna refill his with the names.
I'm there already, okay. Oops. There she is. Perfect. Great, thanks for the help. All right, I've signed that order. Thank you. And I'll step off the bench and let Judge Coker take over.
All right. All right. Back on the record, 9 o'clock calendar, Mr. Bradfield, go ahead. City of Yelm versus Cali Kionis. Good morning. How are you? I'm good. What's your name again?
Celia Lesh, I'm with the Attorney of Records Office, Gargill Law.
Gotcha. All right. What are we doing with Miss Kia Eunice's case today?
Ms. Kionis is appearing through counsel under 3.4B. I do have authority to waive her appearance. We have been in good communication since the prior hearing. She waives her right to the incident at today's hearing. We have a motion to continue to allow for further negotiations. We waive the right to speedy trial. We're asking to reset the complete trials on May 21st at 9 o'clock in the morning. That's granted. That would put the new speedy expiration at August 13th.
Any objection from the city? Good. All right. Thank you, Ms. Lush. So with that, I will sign this order resetting this matter to May 21st of 2026 at 9 a.m. And I've signed the order.
Thank you.
Thank you. Thanks for coming in. Next matter.
But number 1 on the docket, matter of Sheldon Cole.
Good morning.
Good morning.
This is cause number 680097598, City of Yelm versus Sheldon Cole. And your name?
Madeline Denny, I'm covering for Attorney of Record Jay Crone. Bar number is 64716.
Good morning, Ms. Denny. Go ahead. What are we doing with Mr. Cole's case today?
Mr. Cole and the city have reached an agreement. We have a stipulated order of continuance entered in O Courts for your review. And I would just note that part of that stipulated order of continuance is an agreed amendment to the no contact order.
Okay. All righty. All right, Mr. Cole, good morning. So, Mr. Cole, I've been handed forward a stipulated order of continuance. Have you had enough time to go over this with Ms. Denny? Okay, and you understand the contractual nature of this agreement? Okay, and basically, it's a contract between you and the city. So the city's agreeing to not do certain things or do certain things, and you're agreeing to not do certain things or do certain things. And if everybody does those things with no issues, after a period of time, in this case, 12 months, the city would move to, is this going to be result in a dismissal?
Yes, the city will dismiss.
Okay, so at the end of this 12 months, if you've done everything that's contained in this agreement, the city would move to dismiss. If you breach that agreement in some way, shape, or form over the next 12 months, you'll be brought back in And then the city can make a motion to revoke based on your failure to comply with the contract. Then my only role is to determine whether or not you did or did not violate, okay? If your counsel can convince me you didn't violate, well, then I could say, okay, the contract's still in effect. That doesn't happen very often because a lot of times the city, if there's a violation, it's usually pretty obvious. So, but again, it's a good deal. But it does require some effort on your part in terms of compliance and things like that. So any questions you may have for Ms. Denny before I sign this? Okay. All right. Anything else from the city?
Nothing from the city, Your Honor.
All right, so this contains a waiver of speedy trial, which will extend through July 7th of 2027. This is a gross misdemeanor, which means the maximum penalty is 364 days in jail and a $5,000 fine. So if you were to violate, you could technically be sentenced up to that maximum. However, this matter is going to be continued for a period of 12 months. During that time, you're going to pay $150 in court costs. You can make payments on that at the window. You're to appear timely at all court hearings. You're also to have no criminal law violations, and you're to abide by all no contact orders. And I understand there's an amended no contact order in year 2, or,
So we're,
we have modifications in the agreement.
Yeah.
Okay.
I assume we can address after the SOC if we want to do separate paperwork.
Well, so the city does not object to modification of the NCO to allow for written communication, phone calls, video messaging with the children. Okay. I can typically say I'm not going to have any objection to that. And again, also these no contact orders, as Ms. Denny has probably informed you, can be modified later on but usually the protected party is the one that brings that motion and we go from there. Is the protected party present, or has the city spoken to the protected party?
The city has had extensive conversations with the protected party, but not recently.
Okay, but they're aware of the modification? Okay, and they're on board with it?
I believe so, based on my.
Okay.
conversation.
If I may, Your Honor,
Yeah.
I also spoke with the protected party. She was intending to file a similar motion. The protected party and Mr. Cole have some logistic family issues such as insurance coverage that she wishes to discuss with him. She was unable to make it to court today, but expressed her support for this modification to me.
Great, okay. So I've signed the SOC. And then on defense's motion to modify the no contact order to allow for written communication, phone calls, video messaging with the children. I'm indicating defense attorneys does not object, prosecution does not object. So with that stated, I'm going to grant that order and I'll sign that order. And so Mr. Cole, the biggest thing I always say on these things is, you're given an opportunity here to have some communication relates to the children and things like that. If you sense things going sideways, understand that they could come back and ask for the order to be put back the way it was. So just be aware of that and obviously talk to your counsel about that. All right. Okay. So I've signed those orders. Mr. Cole, I wish you best of luck moving forward, and you'll get copies of the windows and you accept the fine payments there as well. All right.
Thank you, Your Honor.
Is that all you have? All right, thank you. Next matter, anything ready?
Is Mr. Newcomb on?
Is that Goodwin, Deontay Goodwin?
Yeah.
Okay. Is Mr. Newcomb on Zoom? All right. Why don't we'll come back to Mr. Newcomb's matter. What case are you here for? What's the last name?
Number 11.
Okay, why don't we call that matter? This is cause number, City of Yelm versus Natalia Rivkin, cause number 6A00106779. Ms. Rivkin is present with counsel. Ms. Johnson, is that right? All right. Good morning. We're here for sentencing. I remember this case from does the prosecutor have copies of these letters?
Yes.
Okay.
Yes, got it.
All right. So are we moving forward with sentencing today? Is that the intent? Okay. All right. So you are Natalia Rivkin? All right. Good morning, Ms. Rivkin. So I will hear from the city first, if I remember correctly. Let me just give me a second. Yeah, we had a fair amount of history. Got it. Okay, I remember this case. So I'll hear from the city as it relates to what was the recommendation on this case,
Mandatory minimums.
which is? Yeah, yep.
Your Honor, I started to misspeak. Ms. Johnson and I had an agreed recommendation. I'll let Ms. Johnson speak for us.
Okay. Ms. Johnson, go ahead.
Thank you, Your Honor. Ms. Rivkin is an alcoholic. She has now admitted that to herself and is beginning the process of admitting that to others. You do see in her history that there was prior offenses. If you notice, it was all within a period of 1 year. And that was a year that was a very traumatic year for her and led to her introduction into the criminal system. She was able to get treatment at that time, and she went through the entire process successfully. Unfortunately, after the treatment process, she felt as though she could do it by herself, and she left the fellowship. She was able to maintain her sobriety for 3.5 years. So, but that whole time, because she had left the program, she was what you call white knuckling it. Meaning that she was abstaining from alcohol, but she wasn't doing the treatment that she ultimately needs in order to be successful, because she is an addict. It's an addiction, but it's also a disability. It's recognized as a disability under federal law and under state law. And that's because it can be life consuming. In March of this year, Natalia hit her rock bottom. She understands that now. And she understands that she cannot do this alone, that the path to recovery requires a fellowship, and it requires ongoing treatment, not only for her alcohol addiction, but also for her severe depression and anxiety. Ms. Rivkin also has ongoing health issues stemming from a gallbladder surgery last year. And that is the reason that we are proposing the alternatives to the mandatory minimums, which are allowable under the statute, which is the 24/7 alcohol monitoring program for 360 days, along with all of the other standard conditions.
So what would be the mandatory minimums on this? Is it 45.90?
120, 150.
Okay.
Ms. Rivkin had her relapse because she went through, she's a survivor of domestic violence. She went through a very painful divorce. She also had the surgery that we mentioned, and so she was unable to work and found herself, you know, without any resources and without any financial means. Because she was not working the program and taking accountability for all of her feelings, she allowed those triggers, those stress points, to lead her back to self-medication with alcohol. And that's exactly what it is, self-medication. Since this relapse, she's been completely sober and she's actively engaged in the AA community. She has a sponsor. She's attended AA meetings every single day. She's been on the Scram device, which is the 24/7 alcohol monitoring, since I believe March 10th, 12th, March 12th. There have been no violations. Alcohol addiction requires treatment, and that is something that incarceration cannot address and does not address. And if Natalia were to be incarcerated, it would surely lead to another relapse upon release. However, if given the opportunity to actively engage in treatment, stay completely sober, and be an active member of the community, that will lead to the road to recovery. And we have the opportunity to do that here. Ms. Ripkin is now employed. She's been working on a regular basis. She has the support of her mother and her sister and her father. Her mother and sister are here present in the court, and I've handed forward letters in support from them. I've also handed forward a letter of support from her AA sponsor, who's now working with her and beginning the process of the 12 steps. Ms. Rivkin has had her evaluation, and she will begin her treatment program. She's been accepted and will begin her treatment program on April 15th. We had set sentencing over so that she could get that process started, and we were hopeful that she would be in the program by the time that we returned here. However, the first opening that the facility had was for the 15th. Ms. Rivkin has Apple insurance, and as the court may know, the number of treatment facilities that accept Apple insurance are few. And the participants who also have Apple insurance and want treatment are the number of participants who want it are far greater than the number of spots available. So it is very difficult with Apple insurance to get a spot in the program, but she has managed to get one, and we'll begin that on the 15th.
What's the status of the deferred prosecution out of Snohomish County?
We will have to address that after this.
Okay.
But she is well aware. And she's well aware of the consequences that will come with that case as well.
All right. All right, Miss Rivkin, anything you'd like to state before sentencing?
Yes, sir. Said. I have said that. I was. Last year was so. I went to the store, I went to the second floor. Back to most of my parents and I was really about the song. For years. It is what it is, and just recently, like, I think they're not, you know, like. It's supposed to be a lot expensive than that. Should never come. I don't like it straight. I'm the place who's gonna take them for outpatient, I mean, inpatient treatment. On this closer, I'm attending the meetings. I don't wanna be surprised if the rest of them. I'm also a lot of kids.
Okay. All right, so I'm looking, again, I just want to make sure I'm clear on this. So I see the pending deferred in Snohomish County. So that's a pending DUI. Then we have a DUI from, and I'm a little it's
I believe they were also home.
yeah, from Snohomish County. It was a DUI amended to a neg driving first with a change of venue. So it kind of made, and then we have a DUI from 2020. So, you know, Ms. Rivkin, the dilemma I see is this, and I did receive the letters from your family and I appreciate that. I read the police reports. Your breath test was a 2.2. You were generally uncooperative with the police. And you were driving without headlights on. So the problem that we have is we have a community problem. I understand it's your problem in the sense of alcohol and the divorces and these sorts of things, but when you're driving around, you're placing all of these people's health at risk, their families at risk. My son and my 2 grandkids live in this town and they're at risk. And I mean, your record is, I get it. Things are clearly going on, but your record is terrible in the last 5 to 6 years. I can tell you most other courts, you'd be looking at a year in jail. They'd put you in jail for a year and that'd be it. You'd sit there, depending on their good time provisions, you'd do 9 months on 12 months. I'm not going to impose a year in jail because I want to hold some jurisdiction over your head for 5 years. But I don't think this is worthy of anything short of the mandatory minimums. In this case, there are 120 days in jail with 150 days of electronic home monitoring. And I'm not going to go below that. Now, I don't know what's happened up in Snohomish County yet as it relates to the deferred prosecution, but if I'm looking at the record, I'm assuming the deferred prosecution will be revoked. That being the case, you for sure have 1 prior. and you have 2 priors. So I think the one up in Snohomish County is gonna be 120, 150 as well. What I'm willing to do is I'm gonna impose a total of 270 days in custody. You're gonna do 120 days in jail, followed by 150 days of electronic home monitoring. You're gonna be on probation for 60 months. You're gonna have to do all the treatment. You're gonna have to do all of those things. Your fine amount is gonna be $2,945.50. You're to not commit any criminal law or criminal traffic violations. You are to maintain law-abiding behavior. You are, I'm looking for the, not to operate a motor vehicle, not to consume or possess any alcohol or non-prescribed drugs. You're not to go to any bars or taverns. Not to drive with a BAC level of 0.08 or higher, or a THC of 5 nanograms or higher. You're to comply with all ignition interlock requirements. You're currently on the scram, is that right? Yeah. Okay. You're not to refuse a breath test in order to do so by this court or probation. I've talked about not possessing. You're going to be on monitored probation for 60 months, substance abuse evaluation. Sounds like you've already done that. You're going to be given a copy of this victims impact panel within 90 days. But what I'm going to do is this. I'm not going to take you into custody today. I want to see what Snohomish County does with the deferred. And I'm going to give you, when's your next court date up there? Do you know?
We don't have a court date yet, Your Honor.
Okay.
But
What I'm gonna do is this, I'm going to give you 60 days to begin serving that time. Which means you'll have to report to the Nisqually jail on or before whatever 60 days from today's date is. If Snohomish County gets resolved and there's a sentence up in Snohomish County, I'm more than willing to readdress this and talk about running time concurrently. Now, what that means is if you get a similar sentence up in Snohomish County, I would consider running this time concurrent with that time, which means that you could knock them both out at the same time. And you can talk to your lawyer about that. But I think what this is going to do is get somebody to contact Snohomish County and find out what's going on, so that case is moving forward. Because if you get information within the next 60 days and you're sentenced up north, then we can put it back on here and we can have a review hearing prior to that 60 days being elapsing, and we can discuss running the time concurrent. Yeah, of course.
would Your Honor consider imposing the 150 on Scram first? Or EHM, whatever your preference is, and then allowing the report, because she could at least get that credit going for
I could do that. Okay. And I'd be okay with that. I'm okay with imposing it'll be, actually it's EHM with Scram. So it's both. So I would allow her to do the EHM with Scram first before the jail time. So what that means is you can't get just credit for the Scram because it's not monitoring. It's monitoring your alcohol consumption. It's not monitoring your freedom. Right. So, but I will allow your attorney to if you, and the Scram devices, I'm no expert on Scram, but I'm pretty sure they can be dual. I know they can be dual purpose. They just need to be triggered to that event. So whoever's providing you the Scram device, if it's Northwest Home Monitoring or some other outfit, they will have both. They just need to be turned on. So you can do the Scram, EHM with Scram first. Okay. And then that should give enough time. And then, so that actually puts off the report date until the EHM is completed. And then by then we should have a better idea what's going on up in Snohomish County as well. City, understand that? Is that okay? Ms. Jones, does that make sense?
Yes.
Okay,
Thank you.
okay. All right, so we're gonna prepare an order to that effect. So Madam Clerk, if you just want to put in the square that she can begin serving the EHM with Scram prior to the jail time. And then, also put on there that, depending on what happens up in Snohomish County, this matter can be readdressed to see whether or not the jail time would run concurrently with any time imposed by, Snohomish County. Make sense? That makes sense, Ms. Johnson? Okay. And I'll remember this case, and it's gonna be in the docket notes too, but, and if the city just understands where I'm going with that as well. Okay, yeah, I think that'll work. So what we're gonna do is you're gonna be released, you remain out in your recognizance today to go get put on. I'm gonna have you, how much time do you think we need to get that turned over? Maybe a week? To get it turned on to the EHM? Because if you get it turned on today, you start getting credit today. So I'll give you a week to get that turned onto the EHM. And then Ms. Johnson, when we get towards the end of the EHM, maybe you note this up for a review, and we can talk about where we are with Snohomish County and where we are with the jail time and all that stuff. And again, the biggest thing here, Ms. Rivkin, is going to be, you need to really dive deep into treatment, because you can't do this anymore. I mean, I know it's easy to say that, but it's hard to say that, because you just simply put, you can't do this anymore. And the next one's going to be a felony, and that's Class B felony. And I think the range is 9. I think the minimum, I think, is 6 to 9 on that. I might be wrong. It might be 9 to 12. So you just got to understand that, and they do push these in Thurston County. I've got one pending right now with somebody. So you cannot do this anymore. Okay? Okay. All righty. I will sign this order. And so I can serve 150 days EHM with Scram prior to jail time, then to serve 120 days in custody at Nisqually Tribal Jail. This matter can be readdressed once Snohomish County case resolved. Jail could run concurrent. All right? Okay.
And the bond will be exonerated?
Bond will be exonerated too. Do we have all that on there?
Are we able to set up a payment program?
You are. It'll be at the front window. Good to go? Okay. Ms. Johnson, I'm going to sign this, and when you get it at the window, I'm going to make sure, if you can just make sure you review it to make sure I didn't screw anything up, and make sure it's consistent with what our understandings are. Okay. Okay, then I will.
Okay.
Okay.
Yeah, we'll step back and review. I have.
Okay, great. Thank you.
Thank you.
And Ms. Rifkin, I really do wish you good luck, okay? Okay. All right, we want to come back to the Newcomb matter real quickly. Thank you. Mr. Newcomb out there? All right, Mr. Newcomb, are you present?
I am, Your Honor, and my apologies. I was present before and desperately trying to punch through, and unfortunately, lacking the technical savvy needed, I was sitting there screaming, "No, wait, I'm ready." We are ready to proceed. I'd ask the court to call the Deontay Goodwin matter, Your Honor.
Okay, this is City of Yelm versus Deontay Goodwin, cause number 5A07283325, and there's also a tracking infraction. Mr. Newcomb is present via Zoom. Are you waiving Mr. Goodwin's appearance under 3.4?
We are, Your Honor.
All right,
And
I think I saw a motion to continue.
there is a motion to continue, and thank you, Your Honor. For the record, Jason Newcomb appearing on behalf of Mr. Goodwin pursuant to a 3.4. We've also been in good contact with him, Your Honor. He understands his obligations to the court. We should have simultaneously filed a speedy trial waiver. In between the last time we were here and this time, Your Honor, Mr. Radfield and I have had some dialogue. We have this case essentially resolved. I'm just asking that it be set over in the normal course to effectuate the plea paperwork. The plan will be to enter it upon our return.
Good. Okay, no objection from the city?
No.
All right. Normal course in this case, depending on your definition of normal, would be June 4th at 9 a.m. That work?
I saw that my clerk had interlineated a date into the proposed order. Is that the date that's on there?
It is June 4th, 9
Perfect.
Okay?
They're the only ones who know where I am on any given day, Your Honor. So yes, that'll be perfect.
Understood. Okay, so I've signed that order. Just advise your client all prior conditions remain in effect and see you back here on June 4th, if not sooner.
Will do, Your Honor. Thank you. Am I excused?
You are. Thank you. Okay, next matter. Or I can just, any other attorneys here? Who do we have? Squally?
Good morning, Your Honor.
Good morning, Mr. Ross. Cause number 1A0190976, City of Yelm versus Shanana Squally?
Shanana Squally, yes, Your Honor.
Hey, Squally. Is Ms. Squally going to be present today?
No, I'm appearing via 3.4 authority, Your Honor.
Okay, what are we doing today?
Your Honor, I've uploaded a proposed motion to continue until June 4th. Ms. Squally has been, if you recall, this is the compromise of misdemeanors.
Yeah, if I remember, you guys were working on getting things paid off and she was making payments.
She's making payments. She just made a significant payment. I don't have a new receipt. I've asked her to follow up with the victim in this case, Your Honor, and she's doing that. But she anticipates that she'll be paid off by the middle of May.
Okay, very good. No objection from the city?
No.
All right, so we're going to reset this matter, Mr. Ross, to June 4th at 9 a.m.
Thank you so much, Your Honor. Thank you, counsel.
Thank you. Have a good rest of your day.
You as well.
Okay, I'm going to call a couple other matters off the 9 a.m. really quickly. City versus Lindsay Gamble. No response. Anything from the city on this one, Ms. Gamble? Do we know?
Yeah, haven't heard from Ms. Gamble, Your Honor. I think she is representing herself.
And this was a controlled substance violation. She didn't qualify for a public.
I haven't heard from any counsel speaking on her behalf. I don't believe there's a notice of appearance in the file either. So city would just like to see a warrant issued in the amount of 500
cash or bond on Ms. Gamble. Next matter, City of Yelm versus Matthew Keeling. Good morning, Mr. Keeling. Mr. Keeling is here on cause number 6A0097600. Mr. Keeling, go and have a seat. So we're on for pretrial. At your arraignment, it was determined that you did not qualify for a court-appointed counsel. Is that still so have you been in contact with Mr. Radfield? All right, so what are we doing today? Okay, so we have a couple points, a couple issues. What we can do is I can confirm for trial. Or we can reset this pretrial out. If you wanted to stick around, you could maybe talk to Mr. Radfield when we get a break. We're probably going to get a break around 10:30-ish, 10:45-ish. So what would you like to do? If you have some time to stick around, you might get a chance to talk to him later today or later this morning. Does that sound good to Mr. Radfield?
Yeah.
All right. So maybe if you have something to do for another half hour, you can come back. Okay. So we'll recall this case. Okay. You're welcome. Last matter on the 9 o'clock, City versus Jacob Potts. Good morning, Mr. Potts. This is cause number 6A0006674. Similar situation, Mr. Potts. You were here for arraignment. We got a couple of charges at that time. I found you were not eligible for court-appointed counsel. Has anything changed in terms of your economic situation? All right. What are we wanting to do today? Have you had any contact with Mr. Bradfield? Okay. So what we can do is he's going to have some time here in about a half hour, 45 minutes. If you want to hang around or come back in about a half hour, we can talk to you a little bit later today or later this morning. Sound good? All right. We'll recall your case. Okay. All right. (9:45) calendar. I'm gonna call, first one I'll call City versus, or Mr. Haverco, do you want me to just call the calendar?
Yeah, go ahead.
Okay, City versus Bayard?
I received a voicemail message that I couldn't quite fully make it out, so I forwarded it to the clerk's office. And I don't know if the clerk was able to discern what she was saying.
So Ms. Bayard sent an email. Well, this email's from January 12th.
All in the same.
Okay,
Just the court date, we set our own March hearing, we confirmed that she be able to make it today. She did mention she's on also next, assured us that she.
Oh.
That same day, she set up a quash hearing with Pierce County District Court, and they happened to be on the same day. She contacted us yesterday to try to figure out if we could change it.
let's reset it 30 days. Note of non-appearance will reset it 30 days. Next matter, City versus Craig Dow. Morning, Mr. Dow. Cause number 580864562. Mr. Dow is present out of custody. This is on for pretrial.
I believe this is the first appearance after the last FTA on 3/26. I
Okay.
haven't had a chance to speak with him.
Okay.
So I'd ask it to reset it to another pretrial, and I'll double check that he's got a working phone number.
All right. Any objection from the city?
No objection.
All right. So Mr. Dow, you're going to be given information again on how to contact, and I have him, he FTA'd on February 26th and March 26th. How did we get back on the calendar? Did he pay a warrant fee?
He did.
Okay.
Quash hearing, but then it was booked on.
Okay. So booked and then released? All right. So Mr. Dow, you're here. You're going to be given contact information on Mr. Haverco. You're going to be given another court date. If we have to issue another warrant, I'll make a point on that warrant to just say, whenever we pick you up, you're going to sit in custody until the next court date, because we got to get this case done at some point. Okay? All right. So, with that, we will, and again, any objection from the city? All right. So Mr. Dow, we're going to give you a new court date. It's going to be May 21st at 11 a.m. and call Mr. Haverco. Okay,
This morning,
this morning, that doesn't count.
yeah.
Call him before the court date.
So I want to confirm with your phone number. All righty. Free to go.
So, he did call you this morning. Hey, Mr. Dow, you got to get a copy of the order at the window. Thank you. Next matter is City versus Jesse Eubanks. And I have a note that Jesse Eubanks may appear at 1. There's some new law violations. So,
Well, I did speak
Oh.
with him, and I anticipated him being here in the morning calendar, but I would hold off, I guess, on issuing a warrant until this afternoon, so.
okay,
So maybe he's still yet to arrive.
right, okay. Next matter, City versus Shallico Green. Come on forward, Mr. Green. This is cause number 580700182. Mr. Green is present, out of custody. On for arraignment for a driving suspended license, third, no ignition interlock, and then we have a pretrial on the same 2 charges.
Yeah, so I'm assuming this would be a first appearance on the pretrial. And so, has your financial circumstances changed? So same financial circumstances, so I'm assuming he would be asking for court-appointed counsel on the arraignment matter.
Okay, I'll go ahead and appoint Mr. Haverco
So
based on the previous appointment.
stipulate probable cause, ask the court to enter not guilty pleas.
Okay. All right, I'm gonna find probable cause for purposes of this hearing only as it relates to the new charges under 5A07000182. Enter pleas of not guilty to both of those charges. Turn to the city in terms of conditions of release.
City's fine with PR.
Okay. So Mr. Green, you've got, the warrants are gonna be quashed. You've got, two pending DWS thirds as well as operating motor vehicle without ignition interlock. The DWS thirds are not the crimes of the century. I see you've shown a Nevada address.
My license for my ID.
Okay. Okay. What a DWS 3 tells me is that you are eligible to get your license. You just have to do certain things that do it. And one of those things is obviously ignition interlock as well. You're going to be given information on how to contact Mr. Haverco. If you get another one of these while this is pending, it'll be a violation of these conditions. So I expect that not to happen. But get your license back. Okay? Okay. All right. I'll sign this order. Your next court date is going to be, write your phone number down again. I have it, but write it down again.
I don't have a working phone number right now, so I'm gonna give you my brother.
Okay, that's fine.
Yeah,
just put brother. Next court date will be May 21st at 10 a.m. All prior conditions remain in effect, including no criminal law violations, no driving without license, a proof of insurance, and you're to comply with all of the ignition interlock requirements per DOL. And stay in touch with Mr. Haverco.
Okay, yeah, just want a copy of today's order, just go see the clerk before you go. Right. Okay.
Yeah, get a copy of the window. Okay, thank you. Next matter is, and I've signed that order. Next matter is City versus Dallas Hazel Rig. Dallas Hazel Rig, cause number 6A0097589, driving with suspended license, first degree on for arraignment, and then cause number 6A0097590, use delivery drug paraphernalia. No response. Anything from Mr. Havertz?
I've had no contact, Your Honor.
Okay. What's city's thoughts on Mr. Hazel Rig?
Is
This is on the warrant quash.
so, yeah.
Yeah, warrant's still in effect. So we need to reissue.
City would like to see a warrant issued for the DWS first in the amount of 2,000 and 500 for drug paraphernalia.
2,500 for 2,500 total. Okay, and then last on the 945 county calendar, City versus Andrea Robinson. No response. This is cause number 6A0021965 on for warrant quash. It's an arraignment. It's a driving with suspended license third and a no ignition interlock. Ms. Robinson previously failed to appear on 2/26/26. And she has failed to appear today.
500 on the DWS third, 2,000 on ignition interlock.
Okay, 2,500 total. No object or we'll reissue that warrant if it's, is it already needed? Was it okay, so $2,500 total catcher bond. All right, brings us to the 10 a.m. calendar.
If we could call on the 10 o'clock, Anthony Benford.
City of Yelm versus Anthony Benford, 6A0089682. Good morning, Mr. Benford. Mr. Benford is present, charged with neg driving first degree. What are we doing with Mr. Benford's case today?
So I think the parties have an agreement. City is going to amend to the civil infraction of improper lane change, to which we will admit $150 penalty. What's that? Improper lane change.
Okay, good morning, Mr. Benford. All right, so based on statements of council, we're gonna get that order. Is that the city making that motion? Do we know the cause number or do we know the RCW?
I can find it.
Okay, I just think we'll need it for the clerk, maybe. Mr. Benford, I'll tell you a story while we're waiting for this to get put together. I was on my motorcycle driving to Spokane years ago, and I was in the middle of nowhere, and I smell something. I smell a cigar. I'm like, I'm smelling this cigar, and there was no cars around me. So I could probably 3 miles ahead of me, I caught a car, and the old guy was sitting in there smoking a cigar. So remember, the powers of your nose are very strong. I'll never forget that.
46, 61, 140.
Got it. All right, Mr. Benford, I've changed this, or the city's motion, we've amended the criminal charge to an infraction of improper lane change under 4661 140. Fine will be $150. You'll get a copy of this. You can set up payments at the window. All right. Anything else on this matter, Mr. Haverco?
Nothing else, Your Honor.
Okay, Mr. Benford, good luck to you. Take care.
Just go to the clerk. Thank you. Yep. And is Tiffany Childs here?
Tiffany Childs is present.
Yeah, why don't you come up? Let's see.
Good morning, Ms. Childs. This is cause number 6A0061885. Ms. Childs is present, out of custody with Mr. Haverco. What are we doing with Ms. Childs' case today?
So we've placed into O courts a stipulated order of continuance, the matter to be continued for 12 months on the condition of no new criminal law violations, payment of a $250 court fee at $25 per month, at the end of which time the city would move to dismiss.
Okay, so Ms. Childs, you had enough time to go over this with Mr. Haverco? And you understand it's a contract? I think, were you here earlier when I went over the contractual nature of this agreement with the previous defendant that was here? Okay, okay. So what it is basically you're agreeing to do certain things in exchange for the city agreeing to do or not do certain things. And in this case, you have a charge of theft third degree, that the city is giving you the opportunity to get that dismissed. And what you need to do is you're giving up your right to a speedy trial through June of 2027. And for the next 12 months, you're going to maintain law-abiding behavior. You're going to pay a probation fee of $250. And you're to appear timely at all court hearings, and you are not to not to go to Walmart. Okay, you're already trespassed from there. If you violate any of those conditions, those will be a violation of this agreement. Okay, and if that happens, you'll be brought back in, and if the city moves to revoke, then I or whoever's sitting here will determine your guilt or innocence based on the police reports. Do you understand that? So I'm looking at your record. I don't see any other, I see one other theft from Thurston County that looks like it was dismissed, maybe a similar resolution. I just want to make sure you understand. How old are you? Okay. Things are changing with thefts in town. And if you get another theft, you're probably going to do jail time. Do you understand that? Okay. So I just want to make sure you're very clear on that. Anything else from the city?
Nothing from the city.
Okay. Anything else from defense?
Nothing else, Your Honor.
All right, I'm gonna go ahead and sign this order, Ms. Childs, and I wish you the best of luck. You seem like a nice person. Don't steal things from places in town, okay? All right, we'll give you a copy of this order. You can set up fine payments at the window.
Did Michael Feeder show up? No.
Is there a Michael B. Feeder, cause number 6A004128, use of drug paraphernalia? No response. It's now 10:20.
I attempted to call him and I had a number, left a message, haven't heard back.
Okay. What's the city's thoughts?
Let's have a warrant issued. Go 1,000.
1,000 cash or bond on Mr. Feeder based on non-appearance. Adam Hash?
He contacted me this morning. He said he's not gonna be here till around 10:30. So I
Okay.
would just recall that.
Called that one, recall that one.
Marina Ketron. And
Morning, Ms. Ketron. Cause number 6A001065, Ms. Ketron is present out of custody. What do we do with Ms. Ketron's case?
we are going to be signing a plea form here. And go ahead and sign. Okay. So Ms. Ketron is going to be entering a straight plea to count 2 of the interlock violation. Then upon the court's acceptance of the plea, city would be moving to dismiss count 1 as part of the agreement.
All right, you are Marina Ketron. All right, Ms. Ketron, I've been handed forward a statement of defendant on plea of guilty. You're pleading guilty to use of drug paraphernalia. In exchange, the city will be dismissing a controlled substance violation and driving with license suspended third. But you're also going to be pleading to a violation of operating a motor vehicle without ignition interlock. Is that your understanding? So those 2 charges, one is a misdemeanor, which is 90 days in jail, $1,000 fine is the maximum. The other is a gross misdemeanor, which is 364 days in jail and a $5,000 fine. You understand by pleading guilty, I could sentence you up to the maximum on both of those, regardless of what anybody recommends. Okay. And at paragraph 5, there's a number of constitutional rights. You understand you're giving up those rights by pleading guilty. And last but not least, discuss any potential immigration issues, Mr.
I have
Adams?
your honor.
Okay. All right. So Ms. Ketron, paragraph 11 states, on February 9th, 2026 in the city of Yelm, I drove a motor vehicle without ignition interlock devices previously ordered by the Department of Licensing. In addition, I also possessed a pipe that I had used and was going to use to smoke an illegal substance, or methamphetamine in this case. Is that your statement? So as to the charge of operating a motor vehicle without ignition interlock, how do you plead guilty or not guilty? And as to the charge of unlawful possession of drug paraphernalia, how do you plead guilty or not guilty? Okay, I'll find your pleas are made knowingly and voluntarily to both, and I'll find.
And also the city would be moving to dismiss on the 653 cause, they'd be moving to dismiss count 2, the
Yes.
controlled substance violation.
Yes. So is motion from the city?
Yes.
Okay. Okay, so on acceptance of the plea, we're going to dismiss the controlled substance violation, knowing possession under cause number ending in 653, and we're also going to dismiss the driving with license suspended third under cause number 652. Are we moving to sentencing today?
We are.
All right, I'll hear from the city first.
Your Honor, it's an agreed recommendation.
It's agreed, Your Honor.
Okay. Ms. Ketron, anything you'd like me to consider before sentencing? Okay.
Are you on any kind of assistance or staff?
It
or-
would work, but it's slow right now. so
Okay.
I don't go back to work until June.
You can make payments on that. So you'll let you set that up at the window. Okay. All right. So, Ms. Ketron, you know, I looked at your driver's status. You're still not licensed. So, yeah, no, it's okay. I'm just saying.
Yeah. Getting my license back in about a week, you know.
Yep.
They've set up starting with the 3rd of next month.
Okay.
Payments
Good.
for, money tickets that I owe or whatever. And then I have to pay $178 reinstatement.
That sounds about right.
And I have to redo my driver's test.
Okay.
I have to do 4 months of.
Ignition interlock. Yep.
Starting next month.
Yep. And it's got to be clean ignition interlock for that 4 months, or they keep extending it. And I've had people in here that have had ignition interlock in for 10 years because they keep violating it.
Okay.
That's good. But you shouldn't do other things too,
I know.
for the record. Okay. All right, so I'm gonna impose 90 days in jail on the use of drug paraphernalia. I'll impose 90 days in jail, suspend all 90 days, impose $1,000 fine. I'll suspend $1,000. On the I'm dismissing the controlled substance violation. I'm dismissing the DWS third, finding you guilty of the no ignition interlock, 364 days in jail, 364 days suspended, $5,000 fine, $5,000 suspended. What I'm going to do, Ms. Ketron, on the fine, I'm going to eliminate the $250 fine. And the reason I'm going to do that is I want you to put the money to get your license back. Okay. So maybe I'll just make the clerk have a docket note that says I reduced the fine so you can use that money to get your license back. But if you come back in on another law violation, I'm not going to give you the same break. Okay.
Thank you, Mayor.
You're welcome. Maintain law-abiding behavior, follow the rules of Department of Licensing. And hopefully we won't see you again. Okay? All right. I'll go ahead and sign this order. And you'll get a copy of this at the window, all right? Yep.
Was Hunter Nicholson here?
All right. Good morning, Mr. Nicholson. This is cause number 6A0006669. Mr. Nicholson is present, out of custody with counsel. What are we doing with Mr. Nicholson today?
He is signing a stipulated order of continuance. Matter to be continued 12 months on the usual conditions, no new criminal law violations, $250 court fee. At the end of which time the city would move to dismiss.
Okay. All right. And you are Hunter Nicholson? All right, Mr. Nicholson, this is cause number 6A, we said 0006669. Have you had enough time to go over the stipulated order of continuance with Mr. Haverko?
Yeah.
Okay. Oh, very good. And you feel like he answered all your questions? Okay. I'm going to go over just a few parts of it in just 1 second. Okay. This matter is going to be continued for a period of 12 months. A theft third charge in this case has a maximum penalty of 364 days in jail with a $5,000 fine. If you were to violate the conditions of this, and you were here earlier when I went over it with the other defendant, you agree to that, you comply with the terms. At the end of 12 months, this matter is dismissed. Make sense? If you don't comply, you're brought back in. Your guilt or innocence, which you've already stipulated to in the police reports, is determined by myself or whatever judge is sitting here. Understand that? Okay. Most important thing here, stay out of trouble. You're probably not having, is this a Walmart case as well? All right. No contact with Walmart. Pay the $250 costs. And if that happens at the end of 12 months, this matter comes up for automatic review. If you've complied with all the conditions, it's automatically dismissed. Okay. You will not have to come back in so long as you're in full compliance. Okay. Anything else from the city? No. Mr. Haverko?
Nothing else, Your Honor.
All right. Mr. Nicholson, I've signed the order. You get a copy at the window. Good luck to you.
Thank you so much.
Yep. Good luck.
Is Monica Perez Cruz here?
Monica Milagros Perez Cruz, 6A0097603, hit and run unattended complicity. Heard anything from her?
Monica?
Is this Monica?
Yeah, this is
Oh,
Monica.
you're here. Good morning.
So we're wanting to, in the SOC, amend to get rid of the complicity component because it's not charged correctly. Just hit and run unattended, but straight, not complicity, and then put it on a 2-year SOC. So
Is there any restitution on this case?
we're going to reserve the issue.
Okay.
So I guess I can amend it to hit and run. Okay, I'll just say hit and run. Okay, I'm just amending it in the form here.
No problem.
And so matter to be continued for 24 months. And I think in the city then at the end of that time was going to dismiss, right?
That's
Yeah.
correct.
Yeah. So.
And is a condition of the SOC going to be restitution?
Well, it's reserved because we don't know
How much?
if the insurance has dealt with it or, you know, I just don't know. So we just thought we would, just put in,
Because I would ask the parties to make at least a condition that prior to the completion of it, that restitution's resolved, one way or the
the
other.
issue of restitution, resolved prior to agreement completion. Okay. So do you know if did you have insurance? Do you know if insurance is taking care of that or? Cause you left, right? So I guess the question is I don't know if she did you have contact with the driver of the other vehicle? Do you even know who they are? Yeah, so one of the challenges here in a case like this is, there wound up not being contact with the injured driver. So that's why I guess my approach would be maybe just to reserve the issue of restitution if it's requested. She could handle that perhaps through her insurance. She apparently did have insurance at the time.
So the alleged victim is named Austin Harrison.
One second.
So maybe the city, yeah.
I mean, I would suggest maybe the city would contact the victim and.
Yep. Yeah, I just want to see something where that's been taken care of. If she's gonna get the benefit of an SOC. And Mr. Harris.
And I would just say, I guess I would consider it taken care of if the victim doesn't make a claim, if they've already handled it and don't want to, you know, so, okay.
And I'm looking at the police reports. We have Mr. Harrison's address.
Right.
And phone number.
Right. I mean, I could give her that information. I just don't know if it's maybe more appropriate if the city,
I think probably the city should.
yeah, but that's my feeling.
Yep.
So. It's a good deal. It's gonna be continued 2 years and if you pay $250 over 2 years, that's all you gotta pay is a total of $250, about $12.50 a month. And then, you'll get dismissed. You won't have anything on the record. Yeah, so I
Good to
think,
go?
I think that's everything, Judge.
All right, you are Monica Perez Cruz. All right, good morning, Ms. Perez Cruz. So, were you here earlier when I went over kind of the stipulated order of continuances with some other folks that were sitting where you are right now? It's a contract. The city's agreeing to do certain things, you're agreeing to do certain things. We just had a conversation about the restitution, for example, and one of the things that I have a little bit of control to some degree on these kind of agreements, because I could technically not, well, I think I could technically reject it. But one thing I'm gonna make as a condition of this contract is that the injured party in this case, their vehicle, that there's some evidence that we come up 2 years from now, and maybe even if you get it resolved sooner than that, the city might, make it a year, but that at the end of this agreement, whoever's car was hit, there's some evidence that the damage was taken care of, whether it's by you, your insurance, or whoever. Okay, so that's going to be a condition of this. If we don't have that at the end of this, for example, that may raise an issue as to whether or not you get the benefit of the bargain here. So it's going to be on you. The city's going to reach out, but also the burden is going to be on you to kind of reach out and say, contact the person that you hit and say, hey, what do I owe for this damage? Okay. And that's part of this process. So, you're waiving your right to a speedy trial through July 9th of 2028. Hit and run unattended is a gross misdemeanor, which means the maximum penalty is 90 days in jail with a $1,000 fine. Restitution is resolved prior to agreement. Again, that may be just a letter from the individual saying it's taken care of. You're going to pay $250 probation fee. Over the course of that 2 years, you're to appear timely at all court hearings and you have no criminal law violations. You understand those conditions? If you do that, at the end of 2 years, this matter will be dismissed. Okay? Any questions? Mr. Haverko, anything else?
Nothing else.
Anything from the city? Okay. And it's not letting me sign. Let me try to refresh. Oh, there we go.
I'm busy.
Okay, I've signed that order and there will be a copy at the window for you. And if you haven't, you might want to check in with Mr. Haverko or with the city in a couple weeks about contacting if anybody's gotten a hold of the alleged victim in the case. Okay? All right. Good luck to you. Next matter would be City versus Amanda Redenkop. Cause number 6A008967. Ms. Redekop is present. What are we doing with Ms. Redekop's case?
Well, I'll have to see if I have time to talk to her. I've been unable to make contact with her.
Okay.
So I'll have to ask you to reseat yourself and I'll see if I can
Okay.
find time to talk to you.
How about City of Yelm versus Haley Stack? Cause number 5A0150703. No response. Any word from Ms. Stack?
I had a phone number, called it more than once, left a message to call me back, received no return calls.
Okay, so cities, we had a warrant back from September 2025. She bailed out.
City would like to see it forfeited and warrant issued in the amount of 500.
Okay, so motion to forfeit the bail and issue a new warrant in the amount of $500 cash or bond. And then City versus Andrew Taylor. Mr. Taylor's present. This is cause number 6A0097592, 6A0097593. Mr. Taylor's present out of custody with Mr. Haverko. What do we do with Mr.
Just one moment.
Okay.
Alfred plea on resisting arrest and the gift to you. He's going to dismiss both. So it's a pretty sweet deal. Okay, yeah, so let me find the form here. We said don't sign yet. Wait, 1 second. One second. So we've got 3 matters on today. As part of a kind of a global agreement here, he is going to be entering an Alford plea to the resisting arrest charge. Pursuant to that, the city would then be amending the suspended driving 3rd-degree charge to no valid operator's license with ID, $150. And then to which we would make an admission. And then pursuant to that, then the city would move to dismiss the mitigation matter.
Okay. All right, and you are Andrew Philip Taylor? All right, Mr. Taylor, what was your highest level of education completed? Okay. Okay. All right, so I've been handed forward a statement to defendant on plea of guilty. Pleading guilty to charge of resisting arrest. The city is amending, is the city making a motion to amend the DWS 3rd?
Yes, sir.
Okay, city's amending the DWS 3rd to a no vol with ID, which is an infraction. And the resisting arrest, is resisting arrest is it a misdemeanor?
It's a misdemeanor.
Okay.
Yeah.
All right, so the maximum penalty on a resisting arrest charge would be 90 days in jail, $1,000 fine. And there's a recommendation contained in here. You understand I don't have to follow if I choose not to. Paragraph 5, you're giving up a number of constitutional rights if I accept your plea. And then any issues, or did you discuss any potential immigration issues, Mr. Haverko?
We did, Your Honor.
Okay. So understand this is going to be an Alford plea, Alfred Newton plea, and as we define them. And what that means is, Mr. Taylor, I'm going to read the police reports and see if the facts are sufficient to support the charge of resisting arrest. So give me just a second and I will do that. All right, so, Mr. Taylor, based on our review of the police reports, uh, the behavior that I'm reading in the police reports is consistent with the, charge of resisting arrest. It's unlawfully hindering an officer in the performance of their official duties. So while I've seen worse, it still meets the legal requirements for resisting arrest, just so you know. Okay, so I will find you guilty of the charge of resisting arrest and find you guilty as such. Are we moving to sentencing today?
We are.
Okay, I'll hear from the city. And one other question, Mr. Taylor, sorry. Have you had enough time to go over this plea form with Mr. Haverco? Did he read it to you or did you read it or both? Okay. Okay. All right, I'll sign that order. All right. And then, Mr. Taylor, anything you'd like me to consider before sentencing? Okay. Do you know what you need to do to get your license back? Okay, I mean, okay, so it's a tough ask, but you at least gotta get on a payment plan or something. Okay. All right, because again, what you're doing is you're just, when you're driving, you're on a heightened level of awareness and stress and everything else because you're looking over your shoulder all the time. So the answer is don't drive or do what you can to get the license things fixed. All right, I'm gonna impose 90 days in jail. I'm gonna suspend all 90. Gonna impose $1,000 fine, suspend all $1,000 for a period of 12 months. Following conditions, I'm gonna dismiss the expired tabs ticket. Dismissing the no insurance ticket and amending the DWS to a no vol with ID. Following conditions, you're gonna pay a $250 probation fee. You're gonna pay the $150 on the no vol with ID, and you're not to operate a motor vehicle without valid license and insurance and those sorts of things, okay? Okay, I'll go ahead and sign this order. And Mr. Taylor, I wish you good luck, all right? And you'll get a copy at the window. You can set up fine payments as well. Okay,
We have one matter we could take up on the 9:45.
sure.
Mr. Eubanks? And we need to just address the arraignment matter in terms of appointment and all that stuff before we proceed.
Okay, this is Jesse Warren Eubanks, cause number 680078686. Mr. Eubank is present. I appreciate you called the court. I think you called Mr. Haverco and said you'd be here a little late, so I appreciate that. So we held on to your file for that purpose. So you are here on a warrant quash. Why'd you miss court last time? Okay. Okay, all right. And appreciate you here today. So we'll go ahead and quash those warrants. We have one matter that's on for arraignment. Mr. Haverco?
So his financial circumstances have not changed, so he would be asking for court-appointed counsel on the arraignment matter.
All right, you shall be appointed.
Thank you, Your Honor. Stipulated probable cause, that said, though, we have an agreement, and that being that, let me just review my notes here. So we're going to be entering a plea to the malicious mischief, the use of drug paraphernalia, dismiss the loitering, dismiss the dangerous knives, stipulating to forfeiture of the knives in question, and then the probation fee to be $125 on each for a total of $250, inclusive of total of both cases combined. And I will have him sign the plea form here.
Okay,
Go ahead and sign it. So he has now signed the plea form.
all right. All right, Mr. Eubanks. So my understanding is you're pleading guilty to the charge of malicious mischief in the third degree. You're pleading guilty to a charge of use of drug paraphernalia. In exchange for those pleas, the city will be moving to dismiss the loitering, drug-related activity and the dangerous knives charge. Is that your understanding? Okay, now, do you feel like you've had enough time to have Mr. Haverco answer all your questions on these cases?
Yeah.
Okay, and did he read this plea form to you, or did you read it to yourself, or both? Okay, all right. And Mr. Haverco, did you discuss any potential immigration issues?
We did, Your Honor.
All right, so Mr. Eubanks, these are, one is a gross misdemeanor, the malicious mischief third is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. The use of drug paraphernalia is a misdemeanor, which means the maximum penalty is 90 days in jail with a $1,000 fine. You understand there's a recommendation here I don't have to follow, I could sentence you up to the maximum? Okay, is that yes? You gotta answer out loud, sorry. Okay, and you understand you're giving up a number of constitutional rights by pleading guilty. All right. Paragraph 11 is a statement that states the following occurred in the city of Yelm on November 6th. Of 2025, I intentionally damaged some planters in front of a business. And then on March 31st, 2026, I knowingly unlawfully possessed paraphernalia that I had recently used and was going to use for the consumption of illegal controlled substances. Is that your statement? Okay. So as to the charge of malicious mischief, third degree, how do you plead guilty or not guilty? As to the charge of possession of illegal drug paraphernalia, how do you plead guilty or not guilty? Okay, find your pleas are made knowingly and voluntarily. No one's made any promises or threats of any kind to cause you to enter the plea. And I'll turn to the parties as it relates to sentencing.
Your Honor, it's an agreed recommendation.
Okay, read, Your Honor.
All right. Mr. Eubanks, anything you'd like to say before sentencing? You don't have to say anything. Okay, is that no? Okay. All right. So I'm going to follow the recommendation. I just want to make one thing. So the planter boxes, do we have any restitution demand on that?
No, Your Honor.
Okay, restitution is going to be reserved on this. And what that means is, I'm hoping the city will reach out to the people whose planter boxes were damaged. And if they suffered a cost, it's going to be something you're going to have to pay. Okay. Do you know why'd you damage the planter boxes?
The moment the obviously gonna have that.
Okay. All right, you're too old for that. Okay. So we're gonna make the restitution part of this agreement. I'm gonna follow the recommendation. I'm gonna impose 364 days in jail. I'm gonna suspend all 364. I'm gonna post $5,000 fine, suspend 5,000 for a period of 12 months. On the drug paraphernalia, 90 days in jail, going to suspend all $90,000 fines, suspend all $1,000, period of 12 months. Dismissing and the city moving to dismiss loitering, drug-related activity and the dangerous knives. Okay. So the city has dismissed those. Following conditions, $250 probation fee. We're going to reserve restitution as we discussed. It would be nice if you went down there. I don't know if said, hey, just so you know, I broke these planter, but do I owe you any money for it? If you do that and you take care of it, you bring proof into the court, that's covering restitution. Okay. Well, is there no contact order or anything like that?
I don't believe so.
Okay.
And I've spoken with the witness regarding restitution on this matter, and to make things worse, it was an employee that paid to repair the planter boxes out of his own pocket. And so he's submitting receipts.
Yeah, okay. So we'll get that, and we'll just make sure we get that to you. So I would like to see that taken care of. Okay. In fact, if you have to defer some of the probation fees while you pay off the restitution, I'd rather see the restitution paid off. Okay. All right, appear timely at all court hearings, no criminal law violations. And then we're gonna forfeit the dangerous knives. And you're gonna pay the restitution and hopefully whatever was going bad on those particular days is taken care of. Okay. All right, I've signed that order. I'm also gonna sign an order forfeiting the seized property. And Mr. Eubanks, we'll see you. You can get a copy of this at the window and I wish you good luck, all right? Okay. All right. Now we're gonna we've got the 11 o'clock calendar next. So what we're gonna do is court's gonna be in recess to allow Mr. Havico to talk to some people. Mr. Ratfield's gonna talk to a couple people. And we'll be in recess for a few minutes. Just, I've got to go make a quick phone call. So just when you guys are ready, let me know. Okay, court will be in recess. All right, you want to take the pro se?
Matter of Mr. Jacob Potts.
Okay.
The 9 o'clock calendar.
Mr. Potts, come forward. All right, Mr. Potts, thanks for your patience. You said this on the 9 o'clock?
It is.
Okay. All right, this is City of Yelm versus Jacob Potts, cause number 6A0006674. Mr. Potts was present out of custody, pro se.
With Brandon.
Okay. All right, Mr. Potts, the city is going to be moving to dismiss with prejudice, which means that this case is done. We'll sign an order to that effect and you'll be able to get a copy at the window. Okay? Thank you. Have a good rest of your day. Thanks for your patience. Thank you.
And Your Honor, we spoke with
Keating? Keeling?
Yes.
Keeling. Matthew Keeling?
that matter to be set over for presentation of the resolution in 2 weeks. Although I'm seeing him in the courtroom and seeing him in the hallway, I think he might have misunderstood, like, told him me, so if we could just reset, 2 weeks and, provide notice.
Okay, do I need to sign anything for that? Okay, so the Keeling matter will reset 2 weeks to April 23rd and send notice and we'll go from there. All right, and Mr. Haverco is back meeting with folks still. All right,
Oh,
Haverco.
thank you, Your Honor. So on the 11 o'clock, it's called Wendy Sassone.
Wendy Sassone.
Yeah.
Cause number 4A09205007. Ms. Sassone is present, out of custody with counsel. What are we doing with Ms. Sassone's case?
One second. We are signing an SOC into O courts. She does have a little bit of history, not a lot, but no prior thefts.
Okay. All right, good afternoon, or good morning, Ms. Sassone. All right, I'm going to pull up what we got going here.
We continued 12 months, 250, the usual conditions.
All right. So, Ms. Sassone, have you had enough time to go over this stipulated order of continuance with Mr. Haverco? Okay, and you understand that in this, part of this agreement is it's a contract. You're giving up a number of constitutional rights, your right to a speedy trial, your right to hear and question witnesses, things of that nature, in exchange for the city agreeing to basically put off prosecution for a period of 12 months. If you stay out of trouble, restitution is reserved, so you'll have to pay any restitution that is part of this. as it relates to, and there's malicious mischief, there's disorderly conduct, attempted assault 3. So there's a lot of charges hanging over your head on this. Do you understand that? And you got to answer out loud. Yes? You have to answer out loud. Do you understand all the?
Oh, Judge, this is Wendy Sassone. It's a single count of theft third.
Oh,
Yeah, you were reading
Look,
down
wrong
into
one,
Colleen
sorry.
Simmons. Yep.
Sorry about that.
Yeah, no problem. Yeah.
All right, let's try it now. Let's try this one. All right, Mrs. Sassone. Now I have an agreement where there's one count of theft third, which is a gross misdemeanor, maximum penalty of 364 days in jail, $5,000 fine. This matter is requested to be continued for a period of 12 months. Under the following conditions, you pay $250 probation fee, appear timely at court hearings, have no criminal law violations, no contact with Safeway. You're waiving your right to a speedy trial, and you're waiving the other constitutional rights that you have as it relates to trial. In exchange, the city, for the next 12 months, will monitor this, and if you comply with all of the terms at the end of 12 months, the charges would be dismissed. Do you understand that? Okay. Have you had enough time to talk to Mr. Haverko about that? Okay. All right. Anything else from the city? Anything else, Mr. Haverko?
No, Your Honor.
All right, Mr. Son, anything else? Anything you'd like to say? All right. Okay, I'm going to sign this you can go to the window, grab a copy of it, and hopefully it gets all taken care of.
Good luck.
Thank you. Good luck.
Next matter is going to be Cade Dawsoner. Come on up, Cade.
Morning, Mr. Dawsoner. This is cause number 5A09329444. Several charges. What are we doing with Mr. Dawsoner?
We have an agreement. On count one, he's going to be pleading guilty to the amended charge of criminal trespass second degree. City will move to dismiss counts 2 and 3, disorderly conduct, obstruction, and then he's also pleading guilty to the resisting arrest. So two simple misdemeanors, and then we'd like to be heard as to the court costs.
Okay. All right, you are Cade Dawsoner? All right, good morning, Mr. Dawsoner. So you're here under, on cause number 5A09329444. I have before me a statement of defendant on plea of guilty. Did you have enough time to go over this with Mr. Haverko? Did he read it to you? Or did you read it yourself or both? Okay. All right. So I'm going to go through some of the high points of this document, and those include the charges we're dealing with that you're intending to plead guilty to, the criminal trespass and the resisting arrest, are both misdemeanors, which means the maximum penalty, 90 days in jail and $1,000 fine on each. Assuming I accept those pleas, then the city will be moving to dismiss the other pending charges. But you understand that there's a recommendation contained in this plea agreement that I don't have to follow. I can sentence you up to the maximum. Okay. All right. And paragraph 11, and Mr. Haverko, was there any immigration issue, or did you discuss any potential immigration issues? Okay. So paragraph 11 states, on December 2nd, 2025, in the city of Yelm, I refused to leave an intercity transit bus after being ordered to do so. As a result of this, I was arrested for criminal trespass and then resisted being arrested. Is that your statement? Okay. As to the charge of criminal trespass second degree, how do you plead, guilty or not guilty? As to the charge of resisting arrest, how do you plead, guilty or not guilty? Okay. Find both your pleas remain knowingly and voluntarily. City moving to dismiss the other counts?
Yes, Your Honor.
All right. Based on that, I'll order dismissal of the disorderly conduct and the charge of obstructing law enforcement, and I will sign.
And then I've shown this to the city, and Mr. Dawsoner would just like the court to have this information. Kind of a program.
Going all the way up to Union for this? Union's nice. How's the treatment going for you? Is it? Were you drunk or high when this event occurred on the bus?
I was actually, trying to go to a meeting to, get into a discipleship house / recovery house that's out here.
Were you still using it that time?
No, I was
Okay,
staying, so.
okay, okay. So the circumstances that gave rise to these charges were not alcohol or drug related, right? Okay. So do you think you can avoid this kind of situation again? Okay, okay. Well, this is great. Is this my copy for the file? Okay. All right. Anything else from the parties? On this one? Okay. All right, Mr. Dossler, I'm going to follow the recommendation. I'm going to impose 90 days in jail on each, going to suspend 90 days in jail on each, impose $1,000 on each and suspend $1,000 on each. Period of 12 months. I've already dismissed the other two counts. Following conditions, you maintain law-abiding behavior, don't commit criminal law, criminal traffic violations, and you're not to go onto the property of intercity transit. Are you able to avoid intercity transit? Okay. There is a recommendation for a $250 fee here. Or there was, it just was removed. I thought, okay. So there will be a $250 monitoring fee on this. You can make payments on that, Mr. Dossner. And other than that, I think we're good to go. So, Mr. Dossner, I wish you best of luck in your treatment that you're doing, and let you get a copy of this to the window. You can set up fine payments at that place, at the probate or the monitoring fees as well at that point. Okay, all right. Good luck to you. Yeah, thank you.
The next matter would be Janet Funk. Sure. Are you sure?
All right, good morning, Ms. Funk. This is cause number 680021961. Ms. Funk is present out of custody with Mr. Haverko. Sorry, here.
She has signed a statement of defendant plead guilty into O courts. All right. All right, Ms. Funk, I have before me a statement of defendant on plea of guilty to one count of theft in the third degree. Did you have enough time? Did you read through this or did Mr. Haverko read it to you? Okay, do you feel like you had enough time for him to answer all your questions? Okay. So paragraph 5 of this document contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand that? And you understand that the maximum penalty on this charge is 364 days in jail with a $5,000 fine. You understand I don't have to follow any recommendation that's contained. I can sentence you up to the maximum. And Mr. Haverko, any immigration, are you discussing any immigration issues with Ms. Funk? I did, Your Honor.
Okay. All right. So Ms. Funk, there is a statement here, paragraph 11 says on January 30th, 2026 in the city of Yelm, I knowingly and unlawfully left Safeway with unpaid for merchandise. Is that your statement?
Yes, sir.
Okay. So as to the charge of theft third degree, how do you plead, guilty or not guilty? Okay, I'll find your plea is made knowingly and voluntarily. No one's made any threats or promises of any kind to cause you to enter the plea. And I'll hear from the city as it relates to sentencing. All right, Mr. Haverko?
Well, it's not a fully agreed recommendation. She, first of all, I would just say she's extremely nervous to be here. Really, she's very upset. She, after leaving the store, she sort of came back and dealt with it at the store. Feels very remorseful, very ashamed. I looked at her record. She actually did have a deferred sentence in front of Judge Creighton back in about
Olympia?
2000, yeah, long.
It was a
time.
long time ago.
Yeah, very long time ago. So I know it's a gigantic ask, but I think she would like to appeal to the court to find out if the city or if the court would consider deferring her sentence and giving her another chance.
Okay. All right. So Ms. Funk, anything you'd like me to consider before sentencing?
Sorry.
That's okay.
I had to go back in because it was kind of right out of his feet.
So you walked back in on your own?
It's a rolling complex.
Yeah.
So when he would beat me up, they said, take it out right now. And I went back in because what kind of example was that?
Right.
You know, and then our 7-year-old, she's like, you can't go get our pizza stick in our free cookie, and you can't, because then I made a mistake, and I told you that.
Yeah.
Sorry.
No, it's okay. Well, I appreciate what you said. I appreciate you taking responsibility for this as well. So I'll follow the recommendation. I'm gonna make it a deferred sentence. Okay, so what that means, Ms. Funk, is this. I look at you have a previous one from 20+ years ago. I think your last criminal event was over 10 years ago and it was unrelated. So what I'll do is I'm gonna impose 364 days in jail, suspend all 364, impose $5,000, suspend $5,000, period of 12 months. It'll be a deferred sentence. So what that means is, if you complain, you can't go back to Safeway. Yeah, and yeah, and what you can do is sometimes if you contact Safeway, they might allow you, but you have to contact them because even if I didn't order you not to go back to Safeway, you can't go back to Safeway because they have a separate trespass order. Okay.
And I believe she. Yeah, right.
Yeah.
She's, and I would ask the court to consider not imposing or imposing less of a financial obligation. She has no source of income right now, lives with her daughter and receives SNAP.
Okay. So, I'll go ahead and reduce the monitoring fee down to 150 from 250.
Okay.
Okay. You can make payments on that.
Sure.
Okay. And then what, you contacted Safeway about trying to get back?
No, just plastic, they're like, no.
No. Well, and
That they said, no, and I'm
Yeah.
not gonna do it.
okay, all right. So, and this will be in the form of a deferred sentence. So if you stay out of trouble, comply with all these things, this matter pops up a year from now, and if you've complied with everything, the charge, your guilty plea from today is withdrawn, and it goes down as a dismissal. Okay? Okay, you're welcome. All right, I'm gonna sign this order. And we'll be able to get you a copy at the window, and you can set up fine payments, and I wish you good luck. Okay.
All right. And the next matter is going to be Amy Hartman.
All right, this is Amy Hartman, cause number 6A00618888. Ms. Hartman is present, out of custody with Mr. Havercom.
She has just signed a statement of found plea of guilty in O courts.
Okay, all right, you are Amy Michelle Hartman. All right, Ms. Hartman. I have before me a statement of let me see what we've got here first. Statement of defendant on plea of guilty to one count of theft in the 3rd degree. Did you read through this with Mr. Haverco, or did he read it to you, or both? Okay, feel like you've had enough time with Mr. Haverco? Okay. Theft third is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand there's a recommendations contained in this document that I don't have to follow. I could sentence you up to the maximum. And paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. And then last but not least, Mr. Haverco, did you discuss any potential immigration issues?
I did, Your Honor.
All right. So Ms. Hartman, at paragraph 11, it states, there's a statement, it says on February 6th, 2026, I was knowingly and unlawfully trying to walk out of Walmart with a vacuum cleaner without paying for it. I was intercepted by Walmart security, the merchandise was recovered, and I confessed to my actions to Yelm police. Is that your statement? So as to the charge of theft in the 3rd degree, how do you plead, guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily. No one's made any threats of harm or any promises to cause you to enter the plea. And I'll hear from the city as it relates to sentencing.
Your Honor,
All right, Mr. Averco?
She wants to ask the court for a deferred sentence. She and I reviewed her criminal history and she acknowledges she has more than one crime of dishonesty back in the kind of 2002, 2004-ish time, and it's 2 or 3 or 4. I don't recall how many, but she just pointed out to me that she's worked over a number of years and has kind of been living responsibly for the most part. And I think in some ways, maybe I'm not sure if she knows why she did what she did, but I told her the difficulty of asking for a deferred sentence with that record. That's a big ask. But she wanted to do that, and so I told her she might want to maybe make some notes to herself and address the court, because I told her the judge would, want to hear from her probably, in that situation. So I think she's done that. She's got a piece of paper in front of her and probably has some things to say to your honor.
Okay. All right, Ms. Hartman, anything you'd like me to consider before sentencing? Sure. Yeah, that's fine.
Well, the reason why it's really important is because I haven't had anything on the record for about 20 years, and I've been a retail manager for 16 years, and it's really hard to. I took a year off to be a big grandson, and I'm trying to go back to work, but I know it's my own fault, but it's really hard to get a job without a reputation. I don't need to be a retail manager. And that I know I did in comparison to and when I was thinking.
Okay. I mean, so I'm looking, so you did a community court program back in 2019 for a theft charge. What's different now than 2019?
I just been under a lot of stress, like I just be a year off and it's like I've been hard trying to find a job again. And then my brother passed away and my grandma, they all like 3 people passed away in like a 6-month period, and I was really stressed out.
So that made you steal a vacuum?
No,
Okay. So I'm just looking at some things. For example, I mean, I know you know this, but so you got a DWS third in 2024, but you're licensed, so that's good. I see the theft that was dismissed. You did community court in Puyallup. You had some shoplifting charges from 2005, 2004, 2002. Probably on drugs at that time. What's the city's thoughts?
City's not. It's a bit too much to ask.
So, what I'm gonna do, Ms. Hartman, what I'm gonna do is this, I think if you earn a deferral, I'll give you a deferral. And I'll leave it up to you. Obviously, I'm gonna impose 364 days in jail, gonna suspend all 364. Gonna impose $5,000 fine, gonna suspend all $5,000 for a period of 12 months. You're not to go back to the Walmart. You're gonna pay $250 as a monitoring fee, and you're to have no law violations. Okay? If you do that for a year and comply with all other conditions, I'll defer this. Now, and it'll be dismissed. What you need to understand is this, even if you're successful and you come back here December of 2027, so beyond a year. I'll see it, I'll know exactly what I did if I'm the person sitting here, or if another judge is sitting here, and you will never get another one of these again in this court. Do you understand that? Okay. But, you know, there are breaks here. I think clearly your old stuff is drug related, but you know, you're gonna go through stress, bad things are gonna happen, people are gonna pass away. But there's no reason to, again, I know exactly what you're talking about, because the job aspect makes it very difficult for you to get a job when these kind of things are on your record. Okay, so I'll give you the benefit of the doubt. Deferred sentence, 12 months, conditions we talked about, you'll get a copy of this order. And at the end of this, if you, it's not letting, oh, there we go. I'm trying to change it to the deferred. Oh, there we go. Got it. Okay. You know, I mean, if you earn it, great. Okay. All right. I'll go ahead and sign this order. And I wish you best of luck and grab a copy at the window. Okay.
Next matter is going to be Kirsten Landry.
This is cause number 5A, City of Yelm versus Kirsten Landry, cause number 5A 0750853. Ms. Landry is present out of custody with Mr. Haverco.
She has just signed a statement of defense on plea of guilty.
All right. Good afternoon, Ms. Landry. Have before me a statement of defense on plea of guilty. Did you read through this, or did Mr. Haverco read it to you, or both? Both? Okay. Do you feel like you had enough time with Mr. Haverco to answer all your, for him to answer all your questions? I need you to speak up a little bit. Okay. And I'm going to go over some of the parts of this. Number one, this is I believe this is a gross misdemeanor.
Yeah, it's an attempted theft second, which makes it a gross
Theft third,
misdemeanor. Yeah.
So,
I think they charge her with that just because they didn't want to drive her out to the county.
yeah.
Yeah.
This is a gross misdemeanor, which could be theft second's a felony. But because they charge this as an attempt, this is what's called a gross misdemeanor. Maximum penalty is 364 days in jail, $5,000 fine. You understand, you're giving up a number of constitutional rights by pleading guilty. All right. And you also understand there's a recommendation here that I don't have to follow. I could sentence you up to the maximum. And again, I'm going to need you to speak up a little bit. Okay. Mr. Haverco, did you discuss any potential immigration issues?
I did, Your Honor.
All right. Ms. Landry, paragraph 11 states, on September 16th, 2025, in the city of Yelm, I attempted and took a substantial step towards committing theft of merchandise from Safeway totaling approximately $850. Is that your statement? So as to the charge of attempted theft in the third degree, how do you plead, guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily, and no one's made any threats or promises of any kind to cause you to make the plea. And I'll sign the guilty plea form as such. I'll hear from the city.
She would ask the court to consider imposing less or no financial obligation. She's in treatment. There's a chemical dependency issue. She's on assistance, a type of disability with the state. It's not federal SSI, but it's some kind of state program. And so apparently, I assume she's working towards some type of family reunification because she's been granted some visitation, or she's able to now see her kids. It's my understanding. So
Where's she in treatment? Where's that? Is it outpatient or in? Okay. You know, you have a warrant out of Olympia. Okay. And you have a warrant out of King County District too. You do. All right. So Miss Landry, anything you'd like me to consider before sentencing? I heard from your attorney, but anything you'd like to add? How long you been clean? Better than not clean. Mhm. Okay. Do you have any credit for jail time on this? Did they take you in? Okay. How much time did you do? Does she have any credit on these things? Who's bailing you out? Huh? No, who's the party that vouched for you? Okay, so you got support of your mom. All right. What I'm gonna do is this. I'm gonna impose 364 days in jail. I'm gonna suspend all 364. And impose $5,000 fine, suspend all $5,000. Keep jurisdiction for 12 months. Impose a probation monitoring fee of $250. You're not to go to Safeway. And then what I'm struggling with here, Ms. Landry, is that you're probably should have been charged with a felony. In fact, by definition, you should have been charged with a felony because you tried to steal more than $750 worth of items. You understand that? Okay. But you're telling me you've been clean for 3 months. Are you is it court ordered treatment or are you just doing treatment on your own? Through what court? Okay. All right. Law abiding behavior, no contact with Safeway. I hope to not see you back here. Okay? All right. Okay. That'll be the sentence. You'll get a copy of this at the window. And I really hope you stay in treatment, Miss Landry. Yeah, no, I think it's fantastic. I trust you. I believe you. I just hope it sticks. Okay. All right. Anything else on Miss Landry's?
Nothing else.
All right, Miss Landry, good luck to you. You can go to the window, grab a copy of the order, and then you can get the fine payments set there.
You're done. Next matter is going to be Colleen Simmons.
Come and have a seat. What's the name again?
Colleen Simmons.
Okay. All right. Good afternoon, Miss Simmons. This is cause number 6A00975599. Ms. Simmons is present out of custody. I think I remember I started to do the SOC on this matter. Is that correct? All right. All right, Ms. Simmons, I have before me, we have multiple charges here.
We're gonna dismiss the disorderly conduct today.
Okay.
The other 3 charges are being placed on the stipulated order of continuance.
Okay.
You know,
All right.
continue 12 months, no law violations, and then 250 and then dismiss.
All right. So Ms. Simmons, have you had enough time to go over this with Mr. Haverco? Okay, and you understand the contractual nature of this agreement? And you understand that you have to do certain things for the next 12 months. If you do those certain things, at the end of 12 months, these other charges would be dismissed? Well, not to get in trouble. You're also giving up some constitutional rights to a speedy trial. You're to pay, there's restitution that's reserved on a malicious mischief charge. And then there's costs and assessments of about $250. And you understand you're to appear timely at all court hearings and have no criminal law violations. So that's your marching orders, so to speak. Do you understand those conditions? Okay. And if you violate those conditions, you understand you'll be brought back to the court and then the city would probably move for revocation. So,
It's a pretty crazy set of facts.
Yeah,
Never
what-
been in trouble. It's just, you know, I think she's sort of questioning herself. What the heck was I doing? We talked at length about this and it sounds like it's just, she was outside of herself. I don't know how else to explain.
yeah, I think I remember you went on arraignment because, you know, an assault 3 range is 1 to 3 months on that. If you're convicted of that, I don't know this, you know, I don't know the circumstances, but I'm looking, you have no criminal history. And then we have this. So, and I think I remember it did look at the police reports. Is whatever led to this, have you got that figured out or taken care of? Okay, all right. Okay, I would tell you for these kind of charges, normally we wouldn't do this, but because of your circumstances, because of what the lawyers, the work that has been done, I'll go ahead and follow this. I don't expect I'll see you back here. Okay. So you're gonna get a copy of this order. You'll pay the $250 or make payments on it, and then just based law-abiding behavior, stay out of trouble, restitution's reserved. You might be getting something from the city as it relates to that. And if you have any questions, you can talk to Mr. Haverco about it. Okay? All right. Good luck to you.
You're welcome. Alexander Zarai.
Good afternoon, Mr. Zarai. This is cause number 6A004127. Mr. Zarai is present, out of custody with Mr. Haverco. What are we doing with Mr. Zarai's case today?
He has just signed a stipulated order of continuance.
Ready? All right, Mr. Zarai, you've been present for these other folks doing these SOCs. Did you have enough time to go over this with Mr. Haverco? Okay, and you understand that you're giving up various constitutional rights by pleading guilty, or I'm sorry, by entering into a stipulated order of continuance? Okay. The conditions are going to be 12 months, stay out of trouble, pay $250 in a probation fees, probation monitoring fees, no criminal law violations, and no contact with Walmart.
Yes.
You understand that? All right. Anything else from the city? Anything else, Mr. Haverco?
Anything else, Your Honor?
All right, Mr. Zarai, is it pronounced Zarai? Zari? All right, Mr. Zari. I mean, it looks like, again, I'm hoping this is just a one-off, you know? So, don't expect to see you back here again. And I'll go ahead and sign this order and, grab a copy at the window. Thank you. Yep, you too.
Going back to the 10 o'clock, if we could call number 10, which is Amanda Redenkop.
All right, Amanda Redenkopf. Good afternoon. Cause number 6A008967. What are we doing with Miss Redenkopf?
She is going to enter a straight plea on count 1 to the amended charge of unlawful use of drug paraphernalia. Upon the court's acceptance of the plea, city would move to dismiss count 2.
Okay. What calendar was this on?
10 o'clock.
10 o'clock. Okay.
Yeah, it's number 10.
Got it. Okay. All right. You are Amanda Redenkopf. All right, Mr. Redikoff, I've got before me a statement of defense on plea of guilty. Did you read through this or did Mr. Haverko read it to you or both? Okay, feel like you had enough time with him to answer any and all questions? Okay, so paragraph 5 of this document contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand those rights? And the charge here is a misdemeanor, I believe. Yep. So it's a misdemeanor, which means the maximum penalty is 90 days in jail with a $1,000 fine. You understand there's a condition, there's a recommendation here. I don't have to follow that recommendation. I could sentence you up to the maximum. Okay. And this is an amended charge from controlled substance knowing possession. So paragraph 11, and have you had a chance to discuss any immigration issues?
We have, Your Honor.
All right. Ms. Redikoff, paragraph 11 states on January 16th, 2026, in the city of Yelm, I knowingly and unlawfully possessed a pipe I had used and was going to use to smoke methamphetamine. Is that your statement? Okay. As to the charge of unlawful possession of drug paraphernalia, how do you plead, guilty or not guilty? I'll find your plea is made knowingly and voluntarily. No one's made any promises of any kind to cause you to enter the plea. All right, we move into sentencing today.
Yes.
Hear from the city.
One second.
All right, Mr. Haverko.
That's right. It's agreed.
All right, Ms. Redikoff, anything you'd like me to consider before sentencing? All right. All right. Ms. Redikoff, I mean, you know, I'm looking at your criminal history. Looks like it's been a few years since you've had anything really. I'm not sure what's going on, but I hope you're not falling back into a bad path. Okay. All right. All right. I'll follow this recommendation. I'll impose 90 days in jail, suspend all 90 days for a period of 12 months, $1,000 fine, suspended for all suspended for a period of 12 months. I'll dismiss the tampering with physical evidence charge. Conditions or law-abiding behavior, you're gonna pay $250 at the window. Make your time, appear at all court hearings and mainly stay out of trouble, okay? Ms. Redikoff, do you understand that? Okay. What's that? You can set payments up at the window, but that'll have to be.
Codes, pay costs. You have no source of income. You're not working.
I'm gonna leave the 250. I'm hoping Ms. Redikoff is getting things turned around. If she wants to approach the court at a later time within the next 12 months to readdress the fines, I'll do that, or the costs, I'll do that at that time. Okay? All right, good luck to you.
Mr. Magseo arrived at about 11:40, so I think technically he's late.
What's the name?
It's Lexio. So I have
Amahamea? Pronounced correctly? Magsayo? All right. All right, this is cause number 680089685. Mr. Megsaw is present with counsel. What do we do with Mr. Megsaw?
Well, I'd like to, I don't know if I need to, if we can treat this as technically as a failure to appear for speedy trial purposes. I would ask that noted for the record and then reset the pretrial hearing. I haven't had a chance to talk to him. I called the numbers that you gave me and it went to the National Guard domestic hotline.
It's a good number. I still have it. It's
Oh, give me your number again, because I.
971. It's a.
512
76.
7600.
Yes, sir.
Is that right? 971 512
Yes.
7600.
It's all online.
Just look something up. Well, the problem was you gave me the wrong. You get, why is that? Why is it doing that?
We know what.
I'm gonna turn my volume off. I don't know why that's making those. You'd give me the wrong area code. You'd give me 253.
Oh, I thought I gave you.
No, you didn't. So that's why, yeah. He'd give me a number 253-971-7600, and it literally did go to the Washington National Guard Domestic Violence Hotline. So apparently the area code is 971. So if the court's willing to treat his appearance at 11:40 as late for purposes of speedy trial, I'd ask just to reset it. I now have a corrected phone number and would ask just to reset this.
Any position in the city? We'll put it on the 23rd of April,
Sure.
take it 2 weeks?
Yep.
Okay.
Yeah,
Take it
I'll
2
give him a
weeks.
call.
Okay.
Yeah, I will. Yep.
I need sign order on that. Okay, we'll do a notice. Next court date will be 2 weeks, April 23rd, 11 a.m. Okay.
That was on the. Just need to have you sign a notice of hearing here. Just give me a second here. Sign it. Okay. All right, free to go. And I think is there an order on Star Young?
Oh, what was that?
There was one in there. I did put it in there.
You can grab a copy of the window, Mr. Mixow.
Did the city on Young want that reset or what?
Yeah, see.
Okay, Star Young. Yeah, come on up. Yeah, come on up. Yeah,
Star Young.
yeah.
This is cause number 680078684. This Young is present with counsel. What are we doing?
We're gonna reset this. Let's see here. Just take me a second. And then we'll talk more. So this is to reset your case. Give us a little more time to chat. Go ahead. Okay. So we placed a motion to continue in courts.
Okay.
And we'd ask to, I don't know, how much time does the city want to set it out to?
Now, I have
discuss?
an order of dismissal in here. It's been trashed. Motion to continue. All right, we want to continue it to when?
What does the city think?
He said.
Sure.
May 7th at 11 a.m.?
Yep.
All right, Ms. Young, your next court hearing is gonna be May 7th.
Well, why don't I, just to double check, why don't, all right. Let me just
10 a.m. or 11 a.m.? Okay. Okay.
Yeah. What? Okay. Yeah, you're free to go.
Next court date's May 7th at 10 a.m.
Yeah.
They will, and then you'll have information on how to get a hold of Mr. Haverco. I heard you discussing he can get a hold of you, and so we'll keep the case moving forward. All right,
Thank you.
thank you.
You're here for a while. Yes. Okay, are you here for 9 o'clock? Oh.
Yeah, I was in there.
What's your name? Lindsay Gamble? Gamble?
I think we did issue a warrant.
Oh, yeah. No, I gotta say this, I was. Well, really, well, this person. Right, yeah, I'm not supposed to be. Right, it says for proceeding, I feel that my. Right. I appreciate it. I would say that, right, you know, the things with these, right, and I'm not trying. Right, so, what's. I don't, was I appointed to her?
I don't know who this is.
Oh, what's your name now?
My name's Lindsay, my last name is Gamble.
She was on the 9 o'clock,
Yes, I have no.
which wouldn't normally be one of mine.
So Miss Gamble, Lindsay Ann Gamble. So you were here, you have a controlled substance knowing possession charge as well as a tracking infraction. And at that, it looks like you did not qualify for she didn't qualify for public defense. Last time you were here.
And then. I guess the big her.
You can, what is your, what has your economic situation changed?
It's just slow season right now, so we if anything, my paycheck is a little bit less, and I'm just about to second, or income there in hours, but
What are you making right now?
About 13.75, like.
Every 2 weeks? And do you have dependents?
I have 2 children,
How old?
4 and 10.
Okay. What I could do is I could appoint Mr. Haverco. I'd have you pay $150 towards to reimburse the city for the costs of that. If that's something you're interested in, you do payments on it. Yeah. All right. So Mr. Haverco, Ms. Gamble's here for a pretrial, controlled substance knowing possession as well as a mitigation. I'm going to appoint you with, she's going to contribute $150 towards to that to offset the costs to the public. Do we want to reset it or do we want to?
Well, yeah, do we, when you appoint counsel, I'm just trying to remember all the ins and outs of the speedy trial rule. Does that restart or do we need to do
Well, this is our first pretrial, I believe. So we could put it out, I'd be okay putting it out a month.
Okay.
It's a possession, controlled substance knowing possession.
Okay. Bama, I need your phone number.
Phone number is 253-327-4270.
I'll let me know. If it becomes an issue, we'll deal with it.
7-0. Okay. And you're gonna need to sign the notice of hearing here. There we go. Sign just half. And then I'll call you.
So do I need to sign an order?
Yep.
Okay.
Yep. Yep. And if you want a copy of the notice of hearing, just go to the clerk and she'll print it up for you if you need it.
So basically just reschedule the same.
Yeah.
thing we already did.
But it'll be on my calendar and then I will talk to you ahead of time and we'll figure
It's
out.
only on Thursdays.
It's always on Thursday. Yeah, yeah.
Oh, general, well,
Well,
for your, it's always on Thursday.
yeah, free to go.
Yep.
Yeah.
You being late.
Oh, no problem. Appreciate coming in. All right.
We could wait until 1 o'clock because we need a break, but just let the court know, Michael Ward on the 1 o'clock calendar is here.
Okay. Let's see.
We do? Oh, he told me he got approval. Oh. Because I told him he needed to get permission from the judge.
City could dismiss on a case that's not on today.
Yeah, right. Do you know what it is?
It's another thing on the road. I think it's a ways out still.
I don't know if he wants to wait until 1.
So what do we want to do with Adam Hash? I mean, he didn't have permission.
I mean, I guess technically without permission, he's not present.
Correct.
I don't know. I talked to him and, and I told him that I couldn't give him permission, that he had to get permission from the,
Was he on the 9 o'clock?
he's on the. I had a proposed,
Let's pull him up.
I had a proposed disposition.
Yeah.
Tonight.
Yeah.
All right, we on the record? All right, this is City of Yelm versus Adam Hash, cause number 480745406 and 480745407. So Mr. Hash, this court has a policy where we will allow Zoom appearances with permission. I've reviewed the file. You do not have permission. You have not requested permission from the court to appear via Zoom. I also show you as an address, with an address of a Yelm address off Yelm Avenue. Are either of those two things incorrect?
The address is incorrect.
Okay, or where do you live?
I live in Ording, Washington, and I had court this morning in Puyallup, and I just got out of it.
Okay, all right, well, so we're not going to be able to hear your case today, but what we can do is reset it. I do actually appreciate you popping on. I'm glad you took care of the Ording matter. Did he
It
call?
wasn't an Ording matter, sir. It was a Puyallup one.
Puyallup one, sorry. Did he call and let us know? Did we know he had court somewhere else today? Okay, so Mr. Hash, just to avoid kind of confusion in the future, if it comes up, it's always good just to call, and the court's staffed pretty well, so you could have called yesterday, a couple days ago. Just let us know, you know what I mean, if you can.
I did, Your Honor. I contacted my attorney as well as contacted the court this morning, and that's how I got the Zoom code. I tried to log into the Zoom code during Puyallup court, and like you said, I needed permission from the judge. I understand that, but I was also thinking that I wasn't going to be in court in Puyallup for 3.5 hours.
Yeah, okay, I got you. And Mr. Haverco did say that you reached out to him.
Oh, yeah, no, he and I did talk, Your Honor, and I just told him that.
Yeah.
It's the court's practice that I can't ask on their behalf, that
Right.
they have to reach out to the court.
All right, so Mr. Hash, what we're gonna do is we're just gonna have to reset this. Do you, I wouldn't mind, how's the 23rd looking? Is it pretty full? We want to reset this to May 7th. Do you know if you have any other court dates on that date?
I don't.
Okay, you don't know, or you don't have any court dates?
I don't have any other court dates on that day.
Okay, It sounds like we're close to a resolution on this case, so you're still, Mr. Haverko is still your attorney. I appreciate you staying in contact with him. We're gonna reset this to May 7th at 10 a.m.
That'll work. Thank you.
Okay, we'll send you notice, but make sure you stay in contact with Mr. Haverko as well.
Okay, thank you.
Okay, thanks, Mr. Ash. Have a good rest of your day.
Yeah, you too.
Take care.
My suggestion is because we're already at 12:40, let's go ahead and break.
Yep.
That's what I was.
Okay. And we have a couple, looks like a couple warrants from the 11 o'clock too. We can
Yeah.
deal with, we'll deal with those first.
Yeah. So
Okay. All right, let me know when we're gonna call. So this is Yelm Municipal Court, afternoon of April 9th. We're gonna call a couple cases really quickly. 11 a.m. calendar, Mr. Haverco, Mr. Radfield. City of Yelm versus Brittany Binkley. Cause number 6A0006657. Ms. Binkley was given notice to be here at 11 a.m. today. She is not here. Do we have any word from her?
Let me get to my notes. Had a phone number, called it more than once, left a message, call back, received no call back, no information.
All right. What's the city's request?
More.
Okay. $1,000 cash or bond for Brittany Binkley. Next matter, City versus Victor Coloco, cause number 5A082-25018. Again, Mr. Coloco had court at 11 a.m. this morning and he did not appear. There's a warrant I issued back in mid-February of 2026. It was $1,000 cash or bond. EFTA'd for pretrial January 12th, February 12th. Again, warrant issued February 12th. He found his way back onto the calendar today, but did not show.
2,500 cash.
$2,500 cash or bond. Any word from him? And Mr. Havercove, I don't hear from you. I'll assume
I
nothing.
don't even at this point have contact information for it.
Okay. Last matter, City of Yelm versus Joshua Peterson, 6A0006658. Mr. Peterson was given notice to be here at 11 a.m. today. Again, no response. Mr. Haverco, anything?
He has no phone and he has not contacted me.
Okay. 500 cash or bond. Okay. That cleans up the 3 o'clock or the 11 o'clocks. We have a couple matters. Is there a Richard Bishop present? Mr. Bishop, why don't you come forward? And is there a Luis Garcia Vargas? Just come forward. Mr. Garcia Vargas, you know, right, you're good right there. I don't think this is an interpreter case. Oh, he does. Okay. So, Mr. Garcia Vargas and Mr. Bishop, my belief is the city is going to move to dismiss your charges based on the fact that you're both relicensed. Okay. Is that correct? Okay. So, the city is moving to dismiss your charges. You guys you're free to go. Thank you. Thank you for getting relicensed. All right. Do I need to sign anything on those or not? Okay. And I think that was all the relicensed people at my last check. Okay. Now we do have an official interpreter matter. Mr. Mold.
Yeah, is that Gutierrez Martinez?
I've got Jesus Fernandez Orozco. Is this Jesus? Are you Jesus Fernandez Orozco? This is cause number 5A0932948. We're here on a mitigation hearing. And it's on for mitigation for infractions. It's a failure to renew expired registration greater than 2 months. No valid operating license with valid ID. No insurance. No vehicle registration. And failure to drive in the right-hand lane. In the right-hand lane. So this is the opportunity for Mr. Fernandez Orozco to explain the circumstances for purposes of mitigation.
I just got my insurance last Saturday.
Okay. Anything else? Okay, let me find that. I can't find the file. Nice. Or wait, I'm sorry. No, this is.
Yes, so this one
Oh, okay.
is his, and then the other.
Okay, gotcha.
Yeah.
Okay. All right, Mr. Fernandez Orozco. Because this is a mitigation hearing, you are acknowledging the violations and you're asking the court to mitigate them in terms of, usually that relates to costs. Looking at a couple things here. Licensed. Okay, so he has insurance now.
This coming Saturday.
Okay. Has he switched, has he transferred the registration yet? Okay, so I'll dismiss the transferring, the failure to transfer, or I'm going to dismiss the operating and possessing vehicle without registration. I'm going to reduce the no insurance ticket from $564 down to $200. I'm going to reduce the failure to renew expired registration greater than 2 months. I'll knock that down from $242 down to $125. $125. And I'm going to reduce the no valid operating license with valid ID from $564 down to $100. And I'll dismiss the failure to drive in the right-hand lane as well. What's the total on that? So I'm reducing the amount of the fine from $1,670 down to $425, down to $425. Okay. Appreciate you getting your license.
Physical license.
He's licensed. You're licensed. So I appreciate getting your license. Next time before you drive, make sure all this stuff's taken care of ahead of time. Okay? So he can go out to the window and set up fine payments on that. Okay? All right. Good luck to you. Do I need to sign an order on that? I do, right? Yeah. Let's see. That was Jesus, right? No. Hold on. What am I looking at here? That was Fernando, that was Jesus. I have a pretrial release condition commitment.
If you refresh.
Oh. Got it. Okay. All right. All right, let me sign this order. Is that Victor Gutierrez Martinez? Sergio Gutierrez Marita? You don't need to try, okay, I don't see, what am I looking at here? Is it Alexis Munoz Medina present? All right, good afternoon, Mr. Munoz Medina. This is cause number 6A0227834. Charges driving with suspended license, 3rd degree. Is the city have motion?
Yeah, city, standing, motion to amend 7.
So the city's amending the charge from a criminal case to an infraction of no valid operating license with ID with a penalty of $150. And he can go to the window and get the form for that. And that'll conclude his case. And I still recommend he get relicensed. You can, yep, they'll set you up at the window. We're not going to help you get your license, but you're eligible for your license through the Department of Licensing, but we don't handle that part of it. There being the Department of Licensing? Yes. Okay. All right. Thank you. And then what's the next one? Is it Gutierrez Martinez? All right. Is there Victor Gutierrez Martinez present? Victor Gutierrez Martinez. Hearing no response. This is cause number 6A0097580. This one, so the city's aware, when I looked this case up, Mr. Gutierrez Martinez is charged with DWS 2nd degree, but he's currently 3rd degree. Amen.
Yeah.
Okay. So Madam Clerk, the city's going to amend the Gutierrez Martinez matter from the DWS 3rd to the no valid operating license with ID and $150 fine. I think that's all. All right, good seeing you. Okay. All right, ladies and gentlemen, we're gonna get to the docket now, the 1 o'clock. Appreciate your patience. So I'm gonna call a series of, you've heard that the city mentioned that their standing order on driving with suspended license thirds is, even though the driving with suspended license 3rd is a criminal case, the city makes the decision to amend those to an infraction, which in this case, that infraction is a no valid operating license, no valid operating license with ID. And it's $150 fine is what the city imposes. It takes it out of the world of criminal case and turns it into an infraction. So if I call your name, that means you're eligible for that reduction, and that's what's going to happen. You then can go to the window outside. There's going to be a line, but you're going to go to the window and you can contest that if you so choose, or you can just schedule times to get on a fine payment to pay the $150. Now, as it relates to the licensing issues, I look at anybody in here who's driving the suspended license 3rd. I'll look at the calendar. Sometimes I'll do it the night before. I did it this morning. So I can see who's relicensed and who's not relicensed. The people that come in relicensed, the city dismisses the charge. Because you're not relicensed, the city reduces it to an infraction with a $150 fine. A lot of the cases I look at, and there are not all of them, but a lot of them are a question of sometimes going in and paying the Department of Licensing $75 to get your license. So I still am a strong advocate for getting your licenses back, but again, if you know, I can only give you advice. So anyway, so I'm going to start at the top of the docket and I'll call the names of the folks who can acknowledge they're here. Then they'll go out to the window outside and get the paperwork for the reduction to the infraction. First one would be City of Yelm versus Tristan Behringer. Is there Tristan Behringer present? Okay, that matter, again, even though Mr. Behringer is not present, that will be amended to a no vol with ID. Next matter would be Roy Hayes. Mr. Hayes, you can go out to the window. Your case is going to be amended to an infraction. So that's between you and the Department of Licensing. I can look up something limitedly. Yeah, so you're suspended third degree. You have a $75 reissue fee, and let me look at one other thing. Yep, you have some tickets out here that are in, looks like maybe collections. So you can set up, you can start making, if you get on a payment plan, it'll release those tickets, which will then let you get your license back. Okay, all right, so go out there to the left and they'll take care of you out there. Okay, next one would be, we dealt with Mr. Hayes. Stephen Herman. Mr. Herman. All right, Mr. Herman, you are same deal. You can go out there and get scheduled with the window. Thank you. Next one is Casey Little, or Casey Little present. Response will still amend that to the no vol with ID. Next one would be is Scott Mendez. Good afternoon, Mr. Mendez. Again, you're licensed, but you're not licensed, but you're eligible. Do you know what you need to do to get your license back?
Yeah.
Okay. All right. So we'll go ahead and go out there to the window, reduce it to a no vol with ID, $150. Thank you. And the next one is there a Gustavo Pelaya Angelano? That one will be amended to a no vol with ID. Chanel Robledo. Your matter will be reduced to the no vol with ID. Okay. All right. You go to the window out there. Thank you. Kashawn Sauer. All right, Mr. Sauer, you heard my speech earlier.
Yes,
So
go back. See that. To get our license renewed.
let me take a look. When did you do that?
I did this.
Okay, well, let me take a look. Kashawn Michael, right? Mr. Kashawn Michael is licensed. You must have done it after I looked this morning. You did. All right. So with that, I believe the city will move to dismiss. So that saves you $150. You're all done? Nope, you're all done. Thanks for getting your license back, and thanks for letting me know too. All right, take care. All right. Next one would be Is there a Cameron Walker Thomas? All right, Mr. Walker Thomas, are you licensed? Okay, so we're gonna reduce it to a no vol with ID, which is an infraction, and you'll go ahead and sign, you'll get proof, you'll get a copy of that at the window. Okay, good luck to you. See. That's it. Anyone else here who's here for driving with suspended license, 3rd degree? That thinks they should have been called. Okay. All right, now we're gonna start at the top of the calendar. Let's start with. We have a Ryan Averill. Ryan Averill. No response. Caleb Bowman. Let's come forward, Mr. Bowman. All right, this is cause number 6A0078687, City of Yelm versus Caleb Bowman. Mr. Bowman is present. Mr. Haverko, I'll turn it over to you for an inquiry.
It takes somewhere around maybe $1,400 a month. He's working.
How much?
1,400 right now. He's working between, it varies, 20 hours a week, 25 hours a week at Dairy Queen.
All right, I'll find you eligible for court appointed counsel at no expense to him, and I'll go ahead and appoint you, Mr. Haverko.
Thank you, Your Honor. Stipulate to probable cause, ask the court to enter a not guilty plea.
Okay, Mr. Bowman, based on the statement of your counsel, I'm going to find probable cause for this hearing only. We're going to enter pleas of not guilty to both counts of assault 4 in this matter. I'm going to hear from the city as it relates to conditions of release. I will say there's an email we got from I think one of the alleged victims, which is Carissa Bowman. Okay, has the city seen that? All right, if you want to just take a look at it real quick. Is there a Carissa Bowman present? Is anybody on Zoom to that effect? Okay. Okay, what are the city's thoughts on conditions of release for Mr. Bowman?
City wasn't gonna be asking for, a strict no contact order, but given, Ms. Bowman's, email, city's fine with, PR and no hostile contact.
Hear from the city? Or I'm sorry, from Mr. Haverko?
I mean, that sounds reasonable.
All right, so I'm looking at, there's actually 2 charges here. Carissa Bowman is one alleged victim, and then there is another, I think Hunter Bowman is the other alleged victim. What's your relationship to Hunter Bowman? Okay, do you live with those folks?
This was the first.
Don't say anything yet, okay. Where have you been staying since you were arrested? Okay, and Mr. Haverko, just so you know, I've got an email from Carissa Bowman. Yeah, and you said Carissa's your sister? Okay,
She's my sister, but she's my legal guardian, but the Bowman is my, all my.
okay,
I was,
okay. All right, so Mr. Bowman, I mean, at least according to this email, it looks like you have these people that want to, they want to help you and support you. And without this email, I would simply just make a no contact order. You're living, you're couch surfing until you get this figured out. But based on the fact that one of the alleged victims reached out, based on the fact that you don't have any history that I see, I'm gonna release you on your own recognizance. I'm gonna impose a restriction in your release conditions that are no hostile contact. So if you and I had a no contact order between you and me, you couldn't have any contact with me, whether you wanted to bring me a birthday present or whatever. If we had a no hostile contact order, we can have contact, but if we start fighting or arguing, that becomes hostile and that becomes a violation of the order. So do you understand those conditions? Now, and so it's a little bit gray, but don't put yourself in a position where the police are going to be called. Don't put yourself in a position where, you know, Carissa or Hunter are going to have to call the police. The other thing is, you know, all they have to do is contact the prosecutor's office and say, look, we screwed up. We need a no contact order and we'll impose one. Okay. Does that make sense? All right. Basically what I'm saying is it looks like you have some folks that want to support you and do what you can to utilize support. All right. Okay. So we've appointed Mr. Haverco. Conditions are no law violations. Keep in contact with Mr. Haverco, stay out of trouble. No hostile contact with Carissa or Hunter Bowman. I'm going to give you another court date, which is going to be May 21st at 11 a.m. And I think that covers it once we get signatures. Okay. So Mr. Bowman, the other thing is you're going to be given information on how to contact Mr. Haverco. Contact him sooner than later so that you guys can keep this case going. Okay? All right. You'll get a copy at the window outside.
I'll call you.
All right. Good luck to you. All right. Next matter would be City versus Gage Conklin. City versus William Dorsey. What's your last name?
Gutierrez Merida.
Gutierrez Merida. Do we have that on the calendar? Oh. Oh, okay. All right. We'll get to you. Thank you though. Okay. William Dorsey, City versus William Dorsey? Nope. All right. City versus Stephen Fawcett. All right. Good afternoon, Mr. Fawcett. This is cause number 680225493. Mr. Fawcett's present, out of custody with Mr. Haverco.
And I think I already represent him on another matter.
Okay. All right, I'll go ahead and appoint you, Mr. Haverco. Has the economic situation changed, Mr. Fawcett? No. Okay. All right, I'll go ahead and appoint Mr. Haverco for this.
Yeah, stipulate probable cause, Your Honor, ask the court to enter not guilty plea.
All right. Based on statements of counsel, I'll find probable cause for this purposes hearing only and will enter a plea of not guilty. Looks to me that we have a pending DUI in Yelm from January, and now we have a DWS second degree. Is that correct?
That's correct.
Is that the city's understanding of this as well?
Yeah.
All right. So, Mr. Fawcett, we have a couple issues here. One, we're going to discuss conditions of release on the DWS second degree first, but then we're also going to talk about the fact that you're in violation of the conditions that I set or whatever judge was here back in January on the DUI. All right. So what are the city's thoughts on the DWS second degree?
City's conflicted.
city's not going to.
So conditions of release.
PR.
Okay. Mr. Haverko?
Well, the defense would agree with that.
On my part. I was under suspended, I got the phone go, set up in my truck, that everything is good, like.
That was my question. There was a pretrial ignition interlock ordered. And I did not see that noted that it was in your truck at the time. Hold on a second. Okay. So, Mr. Fawcett, again, with the Department of Licensing, you've got a reissue fee and things like that. But you have to go and affirmatively go to the Department of Licensing and figure out what you need to do to get your license. Okay, because I see this all the time and I get it. So I believe you, but it doesn't change the fact that you're driving with a suspended license. Okay, so what I'm going to do though is because you had the ignition interlock in, I'm not going to revoke your conditions of release on the DUI. But you are not to drive without a valid license and all other conditions that remain in effect. Okay, all right. So give me an out of custody pretrial, please, with Mr. Haverko. Yeah, if we have him try.
Today I'm going to do the evaluation set.
Make sure you keep him informed of that.
Yeah, we've spoken.
All right, so the next court date's going to be May 7th at 10 a.m. Again, with Mr. Haverko. Sounds like you're going through the things you need to do. Yep. Yep, I get it. Stay out of trouble, no criminal law violations, don't drive without valid license and liability insurance, comply with all the DOL requirements related to ignition interlock. And we'll see you back here on May 7th at 10 a.m. Okay? That's the same date as your other one. We booked them the same.
Thank you very much.
Okay. All right, you'll get a copy at the window. Good luck to you. Next matter, we dealt with that one. City of Yelm versus Dominique Forenash. No response. City of Yelm versus Scott Griggs. Good afternoon, Mr. Griggs. This is cause number 6A0006716. Mr. Scott Griggs is present out of custody with Mr. Haverko for purposes of arraignment. Mr. Haverko, I'll ask you to inquire.
Yeah, salary. Here. 4,000 or more. No, generally right.
Takes home about 4,000 a month, gross about 85,000.
Okay, I'm going to find he's not eligible for court appointed counsel moving forward. I will have you assist him with arraignment today for arraignment purposes only.
Sure.
Okay.
Stipulate probable cause, that's the court to enter not guilty plea.
Okay. All right. Finding probable cause purposes hearing only, entering a plea of not guilty. City's perspective, I see this DUI, I see an open alcohol container infraction from June of 2021. I see a DUI from 2014 that was amended to a reckless driving. So a prior from about 12 years ago.
Standard DUI conditions.
All right, Mr. Haverko.
Seems reasonable.
All right, Mr. Griggs, what I'm going to do is I'm going to release you on your own recognizance under the following conditions. You're not to operate an intermotor vehicle without ignition interlock installed. You're to have that installed within 5 days of today's hearing. Do you understand that?
Okay.
You're not to commit any criminal law, criminal traffic violations. You're not to drive without valid license and proof of liability insurance. You're not to consume any alcohol and operate a motor vehicle. Have no alcohol related infractions. You're not to go to any bars or taverns. You understand those conditions? Is that yes?
Yeah.
Okay. Again, you're to have ignition interlock installed in any vehicle you operate within 5 business days of today's hearing, and we'll have you provide proof to the court. Not going to appoint Mr. Haverco, so you're going to have to hire your own counsel moving forward. Do you anticipate doing that?
Yes.
Is that a yes or, okay. All right. So have him out of custody, retain counsel. Next court date's gonna be May 21st at 9 a.m. You'll be given a copy of this order at the window. And if you retain counsel, make sure they get a copy of this and be in touch with them sooner than later. All right. Mhm. Yeah, if he's gonna drive it, he is. Pre-trial, yes. Okay. All right, next one, City versus Sierra Hanold. City versus Cheyenne House. Okay. Oh, you do? Okay, gotcha. Thank you. All right, and you are Cheyenne House. Am I pronouncing your last name correctly? Haas. Very good. All right, this is City of Yelm versus Cheyenne Haas, cause number 6A0225492. Ms. Haas is present or out of custody, and I have Attorney Ross Britton on Zoom. Good afternoon, Mr. Britton.
Good afternoon, Your Honor. Ross Britton, I'm appearing on behalf of Attorney of Record Barbara Bowden for Ms. House.
Okay. All right. I will turn this over to you, Mr. Britton, for arraignment purposes.
Thank you, Your Honor. Do acknowledge receipt of the complaint in this matter would waive formal reading of that document, asked to enter a plea of not guilty, and for purposes of the arraignment hearing, we will stipulate to probable cause.
All right, Ms. House or Ms. Haas, based on statements of your attorney, we're going to find probable cause for purposes of this hearing only, and we're going to enter a plea of not guilty on your behalf. Now, what I'm going to do is I'm going to turn to the city and talk to them about conditions of release. Okay, I'm not showing any prior DUIs. But that was for him. It's okay. All right. All right. Okay. Request, Mr. Britton, is for standard conditions, which in this case would be PR release, no consumption, standard, no bars, taverns, that sort of thing. Any concerns or objections about those?
No objection, Your Honor.
Okay. So Ms. Haas, I'm going to release you on your own recognizance under the following conditions. You're not to consume or possess any alcohol or non-prescribed drugs. You're not to go to any bars or taverns. You are to maintain law-abiding behavior and not to operate a motor vehicle with any alcohol at all, no alcohol-related infractions. And we're going to give you an out-of-custody pretrial date. What date are we looking at on this? So, Mr. Britton, we're looking at May 7th or May 21st for the pretrial. At what time? At 9 a.m.
Thank you, Your Honor. May 7th, or I apologize, what was the other date?
May 21st.
Your Honor, May 7th looks good in our calendar. Appreciate you giving us that opportunity. If we could have the May 7th pretrial date, please.
May 7th at 9 a.m. Okay. All right, Ms. Haas, you're going to be given a copy of this order. It'll be at the window, and we'll see you back here May 7th at 9 a.m. and stay in touch with your attorney. Okay, thank you.
Thank you, Your Honor. With your permission, if I may exit the virtual courtroom.
You may. Thank you. All right, next matter, City versus Michael Huffman. All right, and now Mr. Sergio Gutierrez Merida. Is it Merida? Yes. Okay, come on up, have a seat. This is cause number 6A002430. Mr. Gutierrez Merida is present, charges driving with license suspended, second degree. Mr. Haverco.
I guess he's unemployed. He's not receiving unemployment because he didn't have enough hours.
Okay, all right, I'll find him eligible for court appointed. Well, and then I'll also indicate here, Mr.
What count-
Ratfield, Mr. Gutierrez Martinez is showing suspended revoked third degree.
What calendar was
Oh.
he on originally?
Looking at the wrong one. Thank you, thank you, thank you.
Oh.
So this is your Sergio. Okay, sorry. Gutierrez, sorry. So where is he on the calendar? I have Gutierrez Martinez, Victor, but I don't have Gutierrez Merida.
Yeah, I can't find it on the.
Let me see.
Your first name is Sergio?
He's on the 1 o'clock. Oh, there he is. Okay, yeah, there he is. I got you. All right, I'm just checking here. Okay. Okay, yeah, he's still suspended second degree. Okay. All right, Mr. Haverco, sorry. I think he's eligible for court appointed counsel at no
Okay.
cost.
Stipulate to probable cause. That's court general not guilty plea.
All right. So Mr. Gutierrez Merida, I'll find probable cause for purposes hearing only. We're gonna enter a plea of not guilty on your behalf. I'm gonna tell you, you got a warrant out of, good. Okay. Very good. Okay, good. So conditions of release from the city. All right. Mr. Gutierrez Merida, we're gonna release you on your own recognizance. Conditions are gonna be law-abiding behavior, no operating motor vehicle without a valid license. I'm gonna make part of it, just get those warrants quashed. Sounds like you're already ahead of the game on that. And based law-abiding behavior, obviously, if there's a licensing issue you can get fixed, let's get it fixed. Okay? You're gonna be given contact information from Mr. Haverco and be in touch with him sooner than later. Next court date is going to be May 21st at 10 a.m. And you'll be given a copy of this. You'll just have to get in line at the window. Yep. All right. Good luck to you. Okay. We already tried Michael Huffman. Adam Jones. All right, Mr. Jones, come forward. All right, good afternoon, Mr. John. I'm asking, yeah, thank you. This is cause number 680227836. Mr. Jones is present out of custody. Mr. Haverco, it looks like Mr. Jones was here previously. He's on a DUI SOC. But that's not on the table today. We're just here for that new charge on arraignment.
Okay. What's your current working situation? You have your income?
Yeah. Yeah, hold on.
What's your total pickup? Takes home about 3,000.
Okay. Dependents, any other dependents other than, okay. What I can do, Mr. Jones, is based on what you make, I can appoint I can appoint representation for you, but I'd have you contribute $200 to that process to offset the cost to the city. I don't know. I'm just telling you where we are. Okay, do you want to do that? Okay, so we'll go ahead and appoint Mr. Haverco and Mr. Jones will contribute $200 to offset the costs to the public. Mr. Haverco.
You have a phone number?
We still need to arraign him.
Stipulate the probable cause, ask the court to enter a guilty plea.
All right, Mr. Jones, based on the statements of counsel, we're going to find probable cause for purposes hearing only, and we're going to enter a plea of not guilty on your behalf. We're going to reset this. We're going to reset this matter for pretrial for May 21st at 11 a.m. This information is all going to be a copy of an order you can pick up at the window. You'll be given Mr. Haverco's information as well. Conditions of release: make all court hearings, no criminal law violations, and stay out of trouble. Okay. All right. Give you a copy. You'll sign this and get a copy at the window.
Oh, before you go, something I'll change to sign. That's the time pay agreement.
That's all. Okay. You're good to go. And all right. Next matter, City versus Kevin Jones. City versus Michael Layden. City versus Richard McCann. All right, why don't you come forward, Mr. McCann? This is cause number 6A0021995. Mr. McCann is present, out of custody. Charge of theft, third degree.
You wants to give me the thing?
Yeah.
Burlington. What do you take home? Takes home between 1,000 and 2,000 a month.
Okay. Any dependents?
Any dependents?
All right, Mr. McCann, what I can do is I can appoint counsel, but I would have you contribute $200 to offset the cost to the public, if that's something you're interested in. All right. So Mr. Haverco, I'll go ahead and appoint you and have Mr. McCann contribute $200 to offset the cost of the public. So I'll turn it over to you.
Thank you. Stipulate the probable cause, as court to enter not guilty plea.
Okay. All right. Find probable cause purposes hearing only. Enter a plea of not guilty. Turn to the city in terms of conditions of release. Request is for a PR release.
50.
All right. So Mr. McCann, I'm going to release you on your own recognizance at this time.
Fine.
Under the following conditions, you are to maintain law-abiding behavior, have no contact with the Apex Grocery and Deli. Is that going to be an issue? Okay. Next court date is going to be May 21st at 10 a.m. Stay in touch with Mr. Haverco, and we'll keep this hearing or this case moving forward. Okay. All right. There'll be a copy of this at the window for you to pick up.
Where you go?
Right.
That's all. Sign one more time. Okay, here you go. I just go see the clerk.
Next matter, City of Yelm versus Reed Metlin. Mr. Metlin, good afternoon. This is cause number 6A0078685. Mr. Metlin is present. Mr. Haverco, I'll have you.
What do you do for a little? When's the last time you worked? Oh, what kind of work were you doing?
Insurance.
Oh, okay. Was doing insurance sales, was an I-9 employee, so he's not eligible for unemployment, so he's not employed at this time.
Okay. I'm sorry, how much is he making? Sorry.
Right now, he's unemployed. He was working laid off.
Yes.
And he's not eligible for unemployment.
Okay. I'll find him eligible for court-appointed counsel based on his current economic status, no cost to Mr. Metlin. So I'll turn over to you, Mr. Haverco.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
All right. Find probable cause purposes hearing only, enter plea of not guilty to one count of assault 4th degree. You're from the city.
You just like to see, order.
That's a real phone number.
Okay. So city's requesting a no contact order condition as part of the conditions of release, and it would be no contact with a Presley Peterson and Andy Rockney. Hear from Mr. Haverco, thoughts?
What's the situation? No. Well, apparently they weren't living together, so there's no issue with a no contact order.
I'm sorry?
There's no issue with a no contact order because they were not residing together.
Yeah, my understanding is there's no relationship here. This event allegations occurred in the school parking lot. Do you know these two people? Okay. All right, we are gonna want a no contact order. Are you putting one together?
Yeah.
Okay. All right, so Mr. Metland, we're gonna relieve.
Question for the court.
Yeah.
Can you have a no contact order in a non-domestic violence case?
I can.
Okay.
It's just not a domestic violence, no contact order.
Okay.
Okay. So, Mr. Metlin, you're gonna be released on your own recognizance following conditions. You're to appear timely at all court hearings. You're to have no criminal law violations. Keep your address up to speed with court and DOL. Only use your true name. You're not to have any contact with or go on the property of the alleged victims in this case, which is initials are PMP and AR. I understand that won't be an issue because you don't know who they are. You know, okay. The other thing is you're not to go on or within 500 feet of the do you live the Yelm Extension School? Do you live near that? How far away from it roughly? Okay. What I'm going to order is you're not to go on the Yelm and on the property of the Yelm Extension School, and that includes the parking lot. Do you understand that? Okay. All right. And this will be in this order, and I think the city's putting together a separate order. So I'll go inside. We're going to give you another court date. It's going to be May 21st at 11 a.m. And you'll be given appointed Mr. Haverco. So I'll sign this order and then I'll also sign the separate no contact order.
You like the two type persons in orders.
That's fine. I'm fine on the same order. Let me know when it's done. Just. Okay. All right. So I'm looking at a separate no contact order, just no contact with the initials PP or AR. We're putting in for 1 year for now, but it's pre-trial. It's not a domestic violence, no contact order. So I'm not issuing any sort of surrender of weapons. No need for a civil standby. Just basically, I'm going to indicate here, you're not to cause or attempt to try to contact them in any way, shape, or form. You're not to make any threats or any other, or keep them under any sort of surveillance. You're not to contact them directly, indirect, or in person, or by phone, mail, or any electronic means. And you're not to knowingly enter or remain or come within. He lives across the street from that school. So I don't know. I'm not comfortable doing 1,000 feet because I think he's there anyways. I don't think I need a distance. I just need, you need to understand, you need to stay away from him.
This is the order signed there.
So I'm okay if you eliminate the distance in feet. And just keep it a general stay away order. Yep. Okay. Okay. All right, Mr. Haverko, I'm going to sign this order. I see the defendant signed it. All right. See you back here at the next court date. Stay in touch with Mr. Haverko. Okay.
Contacting you.
All right. Next matter, City versus Christopher Morales. No response. City versus Trevor Mulca. No response. City versus Sarah Shalhoub. Good afternoon, Ms. Am I pronounced that correctly? All right, Ms. Shalhoub, this is cause number 6A00618994.
Okay.
Ms. Shalhoub is present, out of custody. I'll turn it over to Mr. Haverko.
Has your financial circumstances changed since I last represented? I've represented her in the past a few times, and her circumstances have not changed.
Okay. All right, Ms. Shalhoub, I'm going to appoint Mr. Haverko for the arraignment as well as moving forward. So I'll turn it over to you.
Stipulate to probable cause, ask court not or to ask court to enter not guilty plea. I think possibly the alleged victim is here. I don't know if they want to address the court.
Okay. So Ms. Shalhoub, we're going to find probable cause for purposes of this hearing only. We're going to enter a plea of not guilty at this time. I'm going to hold on a second. So I'm going to turn it over to the city for conditions of release at this point.
You are.
All right. And are you Mr. Tash? Okay, Mr. Tash, if you want to have a conversation with the city prosecutor, you can have it, if they have a time to talk to you here for a second. I don't know what you want to tell the court at this point.
3543.
All right, this is a domestic violence allegation. So city's thoughts on conditions of release.
City, not the city. No. City.
Okay. And Mr. Tash, is it? And you're not requesting, you're asking the court not to enter a no contact order?
No,
Okay. Or do you have concerns about, I mean, I read the allegations at this stage, they're merely allegations. Do you have concerns that you're at risk or you're in danger? No. All right. Okay, Mr. Haverko, any questions?
Well, it sounds like, no, it sounds like the victim doesn't need a no contact order, so I would just ask the court to order no hostile contact.
Okay. All right, what I'm gonna do, Ms. Shalhoub, I'm gonna release you on your own recognizance.
I have a case for his company because of this case. The trying to reach out on communication, then like trying to love the this meeting in jail. That's been trying to like see this. Doesn't mean nothing.
Yeah, so you're gonna be released on your own recognizance under the following conditions. You appear timely at all court hearings, have no criminal law violations, keep your address up to speed with the court. You have no hostile contact with Mr. Tash, Corey Tash. What if this has any effect on Pierce County or any other charges? I don't have any control over that. That'll be up to those courts. Next court date's gonna be May 21st at 10 a.m. You'll be given contact on how to contact, you'll be given information on how to contact Mr. Haverko. So make sure he has good contact for you and then be in touch with him sooner than later. That's not up to me. That's between Mr. Haverko and the city. Okay? All right, I'm signing this order. There'll be a copy at the window.
Yeah, just before you go to see the clerk to get a paper copy of the order, you'll have your clerk do that. Okay. Okay. Well, it's up to the city. I mean, I can't tell you right now, the city's gonna do that.
All right, next matter, City versus Bradley Shepherd. All right, this is cause number 6A0227835. Mr. Shepherd is present out of custody.
Okay, pretty well done. Working about 30 hours a week, minimum wage. He's working about 30 hours per week, Your Honor, minimum wage.
Okay.
Whatever that
All
was.
right, I'll find him eligible for court-appointed counsel at no cost to him, and I'll appoint Mr. Haverko.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
All right, based on that, I'll find probable cause for purposes hearing only and enter a plea of not guilty. Hear from the city in terms of conditions of release.
You have a phone.
Your Honor,
Okay.
I'm sorry.
Okay.
8057.
All right,
Sign here. Pat.
all right. Find probable cause as stated, Mr. Shepherd, I'm gonna release you on your own recognizance. Following conditions, you're not to consume or possess any alcohol while this is pending. You're not to go to the White Horse Tavern. Is that gonna be an issue? Okay. You'd have no contact, but I won't make a formal no contact order. Do you have any reason to have any contact with, Ajawan Payne? Okay, so that's a no? Okay, all right. Okay. Okay, next court date is going to be May 21st, 2026 at 11 a.m. You'll be given information on how to contact Mr. Haverko. Stay in touch with him and we'll see you back here on the 21st. Yes, 11 a.m. All right, there'll be a copy of that order at the window. All right, next matter is Tifi Ta'aloa. No response. City of Yelm versus Michael Ward. All right, Mr. Ward is present, out of custody. This is cause number 6A00976118. Mr. Haverko.
You have any current income right now? You're not working? No. Yeah, how you getting by?
Well, I'm currently a transient. I've been doing side jobs, so free work for people.
Okay.
As far as, trying to get around.
Okay. Okay. Sort of unhoused at the moment, doing a kind of some side jobs here and there, but not any steady, which would be kind of consistent, I think, with the charge too.
Okay.
So yeah, I believe he's indigent. He doesn't really have any significant discernible income.
Okay, I'll find him eligible for court-appointed counsel at no cost to him, and I'll appoint Mr. Haverko for arraignment and the case moving forward.
Stipulate to probable cause as court to enter not guilty plea. You have a
Right.
phone? What is it?
Find probable cause for purpose of this hearing only, enter a plea of not guilty. Conditions of release.
955?
Okay. Recommendations for a PR release.
Okay.
Mr. Haverko, I don't see any even similar.
No. I mean, I think PR is appropriate.
All right, Mr. Ward, I'm gonna PR you just basically law-abiding behavior, okay? Next court date's gonna be May 21st. Do you have a good phone?
Yeah, well, you need a phone.
Currently, yes.
Okay, just make sure I always tell people to stay in touch with Mr. Haverko sooner than later, because obviously this isn't the crime of the century, but it'd be nice to get it figured out. And that's easier if you can talk to him, outside of court. May 21st, 2026 at 10 a.m. No criminal law violations, stay out of trouble, appear timely at all court hearings, okay? And I appreciate your patience. I know you've been here before. You were here before one, so I appreciate your patience. Okay, and I'm sorry your last name starts with W. All right.
Right, I know.
That's okay.
All right, Mr. Ward. You'll get a copy at the window and have a good rest of your day.
No, I'll be calling you. Yeah.
All right, have a good day. All right, Destiny Wilson. Good afternoon. City of Yelm versus Destiny Wilson, cause number 5A058315R. We have Mr. Curtis online as your attorney, I assume? All right, good afternoon, Mr. Curtis.
Good afternoon, Your Honor. James Curtis on behalf of Ms. Destiny Wilson, Your Honor. Your Honor, this is a case that's been refiled. And so we've had a chance to go over the rights at arraignment, and we waive formal reading, enter pleas not guilty.
Thank you. All right, based on that, I will find, and actually it's a DUI charge under 5A058315R and then there's a reckless endangerment charge under 5A058316R. Find probable cause for purposes of hearing only as to both charges and enter plea of not guilty to both of those charges. Hear from the city in terms of conditions of release. Okay, it looks like this is a first offense. It looks like it was back from September of 2025 that was dismissed. It's now refiled. That's the same case. Okay, all right, standard conditions is the request, Mr. Curtis, any thoughts? I mean, that's no alcohol, no bars, taverns, no consumption. Anything else, Mr. Curtis?
No, Your Honor.
Okay. All right, so Ms. Wilson, we're gonna PR release you, which means you're gonna be released on your own recognizance under the following conditions. Not to commit any criminal or criminal traffic violations, gonna order you to have no you're not to presume or consume or possess any alcohol or non-prescribed drugs. If you're asked to submit to a blood or breath test by either this court or a police officer or a treatment facility, you're to submit. And other than that, you stay in touch with Mr. Curtis. Okay. All right. So we will have a out of, what are we looking at? May 7th or 21st or April 23rd? April 23rd is pretty quick turnaround. Oh, okay. So April, we've got some speedy trial issues, Mr. Curtis. So we're looking at April 23rd or May 7th as the next court hearing. If we were to get April 23rd, I mean, again, there'd be no problem entering a continuance at that time, but we would just need a waiver at some point.
Yes, Your Honor. When does speedy expire?
Don't know, do we know? May 11th.
Okay. Yeah, so at this point, my client's not going to do a waiver, so we'll just have to fit it in within that time frame.
So we'll go ahead and set it April 23rd. And then does the city want to put that on for confirmation? Okay, so what we're going to do is we'll set it for a pretrial / confirmation for April 23rd.
Okay.
And then let you be in touch with Mr. Ratfield and we'll go from there. All right, Miss Wilson, we're going to be a copy. I'm going to sign a copy of this order. You'll get a copy at the window. Yeah, that's you need to talk to your lawyer. Yep. Okay.
I didn't hear the question, Your Honor.
The question was, she asked whether or not she needs to be present for the
Oh,
next.
yeah, I'll talk to you about that. Just get the order.
All right, I've signed the order and no, you're good. Thank you. All right, Mr. Curtis, I've signed that order and we'll see you back here on April 23rd.
Thank you.
All right, take care.
Okay.
All right. We have one matter here are you here for fraction at 2 o'clock? What's your name? All right, why don't you come forward, Ms. Philibon? Okay. All right, this is City versus Christina Philibon. This is cause number 6A0101928. Ms. Philibon's present. Ms. Philibon, you're here for a mitigation hearing, which means that you are acknowledging that you committed the infraction in question. You just like to mitigate it or discuss the circumstances. This case is a no insurance ticket that was cited on February 2nd of 2026. Did you have insurance on that day? Okay. Okay. Yep.
Do have insurance current.
Okay. And it looks like this is your first ticket of this type?
Yes.
All right. Okay, what I'm gonna do, and are you Christina Walter? Is that? Okay, you're under Philibon, but you're coming up under Walter. So, all right, what I'm gonna do is, I can knock it down from 564 down to 125. Okay, all right. So I don't sign anything on that, right? Or do I? Okay. So I'll sign an order reducing the fine from $564 down to $125. And then you can make payments on it. You can pick up a copy of that at the window and then you can make payments on it or pay it off, however you want to deal with it. You can make payments on it. Yeah, I mean, you're eligible for a deferral if you want. You've never used a deferral, which is, what are we, 4 months and $100 or something? I mean, you can do a deferral if you so choose. which again would keep it off of your record for purposes, but you get one deferral every 7 years. It's a statutory allowance that allows somebody to defer one non-moving and one, under certain circumstances, one non-moving every 7 years. So what happens is I would be able to see it on your record as a deferral, but it doesn't get reported. If it was a moving violation, for example, it wouldn't get reported to your insurance. But basically 4 months, you pay $100 here. Stay out of trouble, don't have any other similar violations or any violations for 4 months, and then it's dismissed. You want to do that? Okay, we'll do that.
I can make payments on that.
You can't, just has to be paid off within 4 months. Okay. Alrighty, I will sign that order. All right, Ms. Philbom, sign the order. Copy for you at the window. Yeah, yep. Hello, Mr. Robbins.
Good afternoon, Your Honor. I have one matter. It's the Canis Felix.
Okay, this is cause number 6A0002323. Mr. Robbins is here on behalf of, is it Canis Felix?
I believe so, Your Honor.
All right, it's a contested hearing on a speeding charge. I'll turn it over to
Your
you.
Honor, and I apologize.
No, go ahead.
It's a motion to suppress evidence of speed for lack of foundation. The device was in moving mode. However, there's no mention about whether or not he had a calibrated speedometer, which is, of course, a requirement of Washington State Patrol for using the device in moving mode. So we've moved it to suppress evidence of speed and moved to dismiss for insufficient evidence.
I will find that. Let me see. All right, I will find that the report is insufficient as it relates to calibration of the vehicle's speedometer. Based on that, in moving mode, it would be required as a foundational requirement. So I'll grant your motion. Are you moving to dismiss?
Yes, Your Honor.
All right, I'll grant that motion. The infraction is dismissed.
Thank you, Your Honor. Have a good afternoon.
Thank you. You too. Okay, is there a Nathan Fox present? That's cause number 6A0010646. Find him committed. City versus Gina Polling. Two matters, 6A0006672 and 6A0015696. Two counts of operating a motor vehicle without insurance. Any word from that individual, Gina Polling? All right. Based on non-appearance, we'll find them both committed. All right. Warrants. Ryan Averill. These are all from the 1 o'clock. $500. And Mr. Haverco, I assume you will have heard of from none of these folks.
Right,
So,
exactly.
all right. Gage Conklin.
So, go 250 each.
250 each, so 1,000 total. William Dorsey. 500 cash or bond. Dominique Fornash, DUI. Yeah, let me just double check. Let's see. Yeah, it's a first time DUI. So use 2,500 cash or bond on Fornash. Sierra or Luis. Do we deal with Luis Garcia Vargas? Yeah. He got licensed. We dismissed it. Sierra Hanold. Drug paraphernalia. 500 cash or bond. Michael Huffman. DWS first, operating without ignition interlock.
Go,
1,000 on each. Kevin Jones. 500 cash or bond. Michael Layden. He's got a prior from 2010. I'll go 5,000. Let's go 5,000 cash or bond on Layden. And Christopher Morales. All right. Trevor Molka. Actually, hold on one second. Let's go back to Morales. I wanted to see, because I remember that name. So he's got a theft. He has our theft from December 2nd. Found guilty of a theft December 12th in Lacey. Theft from May 12th, guilty. Theft from December 2024, guilty. Another theft from September, guilty. I'd say 5,000 cash or bond. All right. Trevor Molka. It's crim trespass first. $1,000 cash or bond. And Tifi Ta'alolo. Reckless drive. $1,000 cash or bond. Okay. All right.